order. First up, we have the roll call.
Sorry, you want to call me or?
Yeah, let's go.
Thank you.
Okay. Chairman Designee Lee.
Here.
Commissioner Harmon Smith.
Here.
Commissioner Harris Ritter.
Here.
Commissioner Williams.
Here.
Commissioner Luther.
Here.
Commissioner Brooks. Commissioner Clemmer.
Here.
Oh,
Commissioner Brooks, are you on the line?
Yes.
Okay, thank you. All right, next we've got the invocation. If y'all join me in standing. Lord, we thank you for this day. We ask for your blessing. We pray that you'll guide this board, fill us with your spirit and your wisdom. Pray safe travels for everyone that's attending on their way back home. In Jesus' name we pray. Amen. All right, and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation.
This meeting is being recorded. This meeting is being transcribed.
Thank you all. Y'all be seated. All right, first up, we've got approval of the May 21st minutes. Director Madison.
This was sent out to the board with requests for any changes or comments on it, and so we're ready to answer any questions on the minutes from the May 21st meeting.
I move we approve the minutes from the May 21st meeting.
Second.
All right, all in favor of approval of the May 21st meeting minutes, say aye.
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 Thank you. It's unanimous. Now we'll go into our public hearing regarding SBEC case number 2024-045. I'm going to step to the side, and we're going to invite our hearing officer up.
Mr. Bolton.
Mr. Bolton.
And since I'm the first witness, I'm going to stay here at the witness seat.
Right here, sir.
All right, good morning, Commissioners.
Good morning.
It appears that you're stuck with me again. I've got on the,
He said, "You want to finish the shopping?" I said, "We will have some time for shopping on Friday, when we get done. We'll have clerks that want to go shopping when we leave." Right up. I said, "You got some."
Thanks, John.
all right, the first time, the only item on this docket is SBEC docket number 2024-045. Would council be so kind as to identify themselves for the record, please?
My name is Jonathan Kendricks. I am the attorney for the SBC.
Mr. Gibson?
I'm Cliff Gibson, attorney for Sherry Collins and Michelle Hammonds.
Mr. Gibson, you seem to be a little hoarse this morning. Are you all right?
I'm here. And I have a condition that has impaired my voice, and I am receiving treatments.
All right.
My wife considered it to be a blessing.
There's a lot of blessings, Mr. Gibson.
Yeah.
I don't know about having a hoarse voice might be one of them, but, depending on your perspective.
Sure.
All right, let me take judicial notice about the statutes as well as the rules that are governing this proceeding.
Do we have the binder book for,
Yeah.
look in the binder book there.
This one?
This one is there we go.
Even better. Thank you so much, please. All right, I've got a number of exhibits, I believe. Let's see here. Maybe Ms. She could help me out here. How many exhibits do we have that you want to introduce?
From the SBC, we have exhibits 4.1 through 4.18, which are in that white binder in front of you. And then we've got exhibits T1 through T4, which are the red book, so the training guide and checklist for poll workers, as well as a test answer and a couple of slides from the training materials.
Gibson, do you have any objection to the admission of staff's exhibits?
They were provided to me before the meeting. I said, they're saying.
Any objection, sir?
I said no objection.
Thank you so much. Without objection, those exhibits are admitted into record. Mr. Gibson, do you have any of your own exhibits that aren't already part of this packet that you would like the commission to review here this morning?
Yes.
Okay. And what are those, sir?
You should have a binder in front of you, do you?
I'm not certain what I do. Okay. I do?
Yep.
Yes, sir?
It's exhibits.
This blue binder?
Yeah, I'm going to submit, this is a memorandum brief for consideration by this board. And exhibits A through H are bound with that brief. And we're submitting them brief and the exhibits for this hearing is to be received in this hearing by this board.
All right. Any objection to the admission of these exhibits, Mr.
No,
Gibson?
sir, there are no objections.
All right. Without objection, respondents' exhibits are also admitted. Commissioners, do you need a few minutes to review these exhibits before we press forward? Or are you satisfied with what you've already received and taken a look at and are ready to proceed? What's the prerogative of the commission?
I would like a few minutes.
All right. We'll go ahead and go off the record for 10 minutes, if that's fine. Commissioner?
Yes.
You give me the high sign when you are ready to proceed, and then we will get into opening statements.
Thank
We're
you.
off the record. Let me double back and acknowledge with specificity the actual statutes and rules that are governing this hearing. Arkansas Code annotated 7-4-101, as well as 74120, with the exception of 103A1, 4, 6, and 7, as well as the Arkansas Administrative Procedures Act. Gentlemen, would you like to make an opening statement?
We would like to waive our opening statement.
Wait. All right. Mr. Gibson?
I'm not capable of giving one, okay? But I'm going to try to say a few words here.
All right, go ahead, sir.
As I appreciated the brief that we submitted to the board and exhibits to that have been received as evidence in this case.
They have.
Okay. And also, too, in Mr. Kendrick's exhibits, there's a document called stipulations or facts that we agreed on. Okay? It's a 2-page document. I would suggest, respectfully, that the commissioners have a chance to read those 2 pages. It's in the binder.
Exhibit 3.
I believe that's right.
I believe it's
It is exhibit 3.
kind of tab 3.
I just thought it might be helpful for them to see it. And quite frankly, I do have one remark that I want to make. The reason my brief is longer than normal in a proceeding like this, it's about 10 pages or so, is because of my voice problems, which the doctor assures me is going to correct itself. Hope he's right. But anyway, our legal positions are all set forth in that brief. And we ask respectfully that the commissioners review that brief carefully before they decide to take a vote.
Okay.
And that would conclude my opening remarks. Thank you.
Thank you, Mr. Gibson.
Yes, ma'am. Yes, sir.
Ladies, I don't know whether or not, I'm fairly confident Mr. Gibson kind of gave you an idea of how this process works. I don't know if you've ever been in an administrative hearing before, have you?
No, sir.
All right. So let me explain what's going to happen. Mr. Kendrick's going to go first. He's going to call whatever witnesses he's got, examine them, then Mr. Gibson will have an opportunity to cross-examination, and then after that, the commissioners may ask questions as well. As the hearing officer, I'm in the hearing for the benefit of the commission, but it's also for your benefit as well. I don't make the decision. They do. I'm just here to facilitate and run the hearing for everyone's benefit. Once Mr. Kendricks is done with his case, it'll be Mr. Gibson's turn. I assume he'll call both of you ladies as witnesses. Once he is done questioning you, Mr. Kendricks may ask you some questions. The commission may ask you some questions as well. Once all the evidence is done, I call the record to a close, at least the evidentiary part of the record. Commission goes off the record, they go off the record. They deliberate, and then once you reach a decision, they come back on the record and
We don't go
announce out.
off the record.
Off the transcript record for purposes of a court appeal, it's still a public meeting.
Right.
And we continue the broadcast and the recording, but the
Right,
transcript
but
portion.
I understand that, but we have not gone off the record for that part in the past.
I couldn't remember, some boards and commissions do, and I know the trend lately, Commissioner, is to have everybody stay on the record.
Right.
But it's the prerogative of the commission. You still have that slight flexibility.
I understand,
Okay, but
but I
whatever
think
you
it's
want.
important for us to stay on the record.
You can do that. You can do that. Just so long as everyone is cognizant of the fact that it's one at a time speaking, and you can't speak over one another.
Right.
Some boards and commissions tend to do that. That's why they go off the record. In any event, once they reach a decision, they'll come back on the record, they'll announce it with a motion and vote. Okay? If at any time you've got a question, you want to know what's happening, if you can't get my attention, get a hold of Mr. Gibson, he'll bring it to my attention. Okay?
Yes, sir.
Any questions for me?
No, sir.
All right, thank you, ladies.
Thank you.
All right. Mr. Kendricks, your first witness?
May I ask a question?
Sure.
I don't know whether the commissioners had a chance to read the stipulations. The reason why I would like for them to do that, we agreed on it, what it
Right.
says. And the reason I'd like for them to have that chance is because it lays the background for how this matter arose.
Well, Mr. Gibson, we went off the record for about 10 minutes to give them a chance to read.
That was our brief.
No, it was everything.
Oh, everything.
Yeah, basically, I gave them a chance to review everything through that had been
They're
admitted.
faster than me.
Well, I didn't do the reading, they did. Mr.
I
Gibson,
understand
so-
that.
All right, how about your first witness, Mr. Kendricks?
Sir, Commissioners, we would like to call Director Madison as our first witness.
Director, if you would be so kind. Do you swear affirm the testimony you're about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Mr. Kendricks?
Sir, could you please state your name and your position?
My name is Chris Madison. I'm the director for the State Board of Election Commissioners.
Can you detail your involvement in the training of the poll worker trainers?
So as the board is aware, we conduct training for trainers across the state that train poll workers. As part of that training, we give lecture and PowerPoint as well as materials that we hand out. And one of the provisions that's covered with the trainers and the county board's election commissioners and coordinators relates to electioneering, which is what the basis of this case is. And I present that section of our presentations to the trainers.
Will you please define electioneering for the board? And if you need a refresher, you can refer to Exhibit F in the respondent's packet.
So the definition of electioneering is based on state law, and it's 71103 subsection A8. And the law defines electioneering means the display of or audible dissemination of information that advocates for or against any candidate, issue, or measure on a ballot. And then it gives some different examples, continued on in the statute, where it lays out this is the type of things that include electioneering.
Will you please give an example of what electioneering would be?
So when I'm giving the presentation and speaking to the trainers and teaching on this, we give an example of if I'm wearing during a presidential election, Make America Great Again. That is a slogan for one of the candidates, President Trump. If Make America Great Again is a slogan that is identified with one of the candidates during the presidential election, that would be an example of electioneering, wearing that into the poll within 100 foot. Similarly, I give an example, we had a complaint in 2020 of a lady who showed up to the poll wearing a Hillary 2016 shirt. Well, Hillary was not on the ballot in 2020, and that's an example of not electioneering based on how we applied as a candidate or issue on the ballot.
And could you please detail the training that is given on electioneering to the trainers?
So we discuss with trainers, when we're teaching this, we talk about electioneering, and I often joke that while we have poll judges and poll sheriffs, sheriffs aren't actual police. And this is a criminal provision, electioneering is a crime, but you're not the police, and we don't want poll workers trying to enforce the law to this aspect. However, what we do instruct them is tell the poll workers to ask the person to comply if they believe what they're doing is electioneering related to the ballot. Ask them to comply. If they don't, if the voter does not want to comply, well, they're probably there to try and cause a stink anyway. I mean, that's really what it's about. And what we instruct is that in that case, if the voter refuses and is not wanting to be compliant, then we tell them to vote the person and get them out. And the reason being is once they vote, that voter no longer has the lawful right to be in the poll. And if they're there to try and cause problems, voting them and getting them out is it is the de-escalation effect that we're trying to do to get them out of the poll. And that's the instruction we give on it. We do ask that they document it, the who, the what, the when, if they can get pictures of it, videos of it, and submit that to us as a complaint. We will follow up on it, and we have in the past, and have actually gotten warrants and people arrested for committing electioneering based on evidence that was provided by poll workers and observers. And because we don't want poll workers having to get into conflict with voters over these type of things, and that's how we structure our training.
Could you go into a little more detail on how the electioneering law is enforced?
So as I just said, we ask that the poll workers ask the person for compliance, and that works 90% of the time. If they're engaged in electioneering wearing something that's tied to a candidate on the ballot. If that doesn't, we ask them to, hey, just have them vote them and get them out. Because once you voted, again, you don't have the right. But document, like I said a moment ago, the who, the what, the when, photograph it if possible, get as much information, and submit it to us through a complaint process so we can follow up on it. And we get those regularly, and we follow up on it.
Do the poll workers get tested on this information?
So we test, the state board tests coordinators, trainers, and CBCs, and then we have a test for the trainers to use for poll workers because we want them to have at least a base level of knowledge. And we provide a test that's actually in the poll worker training guidebook as a basis that trainers are to use for testing their poll workers.
And for reference, if the board and Mr. Madison could turn to the last page in the red book in T1, Exhibit T1. So as far as testing on electioneering, is that what questions 38 and 39 are going towards?
Yes, that's correct.
And board, if you will look at the test answers, which is Exhibit T2 as well. So if a poll worker were to do either of the incorrect answers for question number 39, what would happen? What would they be doing?
So question 39 is what should a poll worker do if a voter refuses to remove a campaign shirt promoting a candidate on the ballot when asked? And one of the incorrect answers is not allow the voter to vote. Pull the voter out of line, call the police, and really what you're doing is you're preventing the voter from exercising their right to vote.
And that would be an election law violation.
That's correct.
Okay. And then as far as complaints being filed, are there two forms?
So this is an issue that has created some challenges. We have our state board complaint form that is signed under penalty of perjury. There is also a form that is prepared by the Secretary of State's office that is the voting machine complaint form, and it relates to the operation of voting equipment in the poll. And so there's the two separate forms. The complaint form with us is signed under penalty of perjury. The voting machine complaint form is not.
And for the board, if you want to see both of the forms, you can turn to Exhibit 4.1 in the white binder. The front of the first page is the SBEC complaint form that Mr. Madison just referenced, and the back of that same page is the Secretary of State voting machine form that he just mentioned.
That is correct. That's the two different forms.
And what training is given to the trainers for to tell the poll workers who they go to if they have a question on election day.
And this is part of the training that we give both for electioneering, and the electioneering is part of our election day problems section of training, and it's where we're discussing things that could go sideways in the poll. And so the overarching process is that the first check-in person is having challenges with a voter. They're to notify the poll supervisor. Poll supervisor is to notify either the CBC or the coordinator or somebody above them. And then we also instruct them if they have questions about applications of these laws or policies, contact us because we're the ones that enforce these things on the back end. So as part of our training is you as a poll worker contact your supervisor, supervisor contact CBC or the clerk if you're voting early clerk, and then contact us related to these issues because these are the things that we train on, we enforce, and we have the enforcement authority.
And then my final question, to the best of your knowledge, did your county use any materials other than the SBEC training materials?
To the best of my knowledge, no. And the point of that is we have some counties that develop their own training materials. For example, Pulaski and Washington County develop their own training materials that the board has to approve. They submit it to us, we review it, make sure it checks all the boxes it needs to, and I'm not aware of Drew County doing that.
You rest.
Thank you, Mr. Kendricks. Mr. Gibson?
Oh, yes, sir. Thank you. Thank you very much. Mr. Madison, I was listening as close as I could, and I'm going to try to ask you some questions. If I don't make them, if you can't understand me, tell me, and I'll try to do something. Shouldn't take but a minute. The test that Mr. Kendricks asked you about.
Yes, sir.
In the back of exhibit number T1. In fact, it's on page, the book is 85 pages long. I see that, and literally this is on the last page of it, isn't it? That entire booklet.
It is, yes, sir.
Okay, and that's exhibit T1. And I was curious, on page 83, at the top of the page, what does it say in the first line?
Advanced poll workers.
Yeah. Do you know whether this advanced poll worker part of the test was ever given to Ms. Collins or Ms. Hammonds?
I do not.
Okay. And in fact, as I appreciate it, you can't say that they ever received any training because you're not involved in the training that's provided to them. Is that right?
I can say that they're legally required to receive training prior to working the primary, and that they're required to have completed the training within 12 months of working the general election.
But you don't know if this test that's been pointed out, you don't know as we sit here on under your oath whether these tests or anything about electioneering was given to Ms. Collins or to Ms. Hammonds. Am I correct?
I can say that the state board as trainers did not give it specifically to them, but we did give it to the trainers for the county.
Right. And it depends on the trainers that you train to train the poll workers. Right?
That's correct.
And so you can't say here today that these ladies actually received training on question number 39. Can you?
I cannot.
Okay. And in the entire book, T1, is there a page in there that instructs people on what electioneering is?
Yes, sir. If you'll turn to page 55.
55.
Yes, sir.
I seem to remember that was the page number.
I figured you did.
Yeah. All right. And so 55, is that the only training that's given out with these books to poll workers?
No, sir. Also on page 53 is discussion related to electioneering.
All right. I see. Well, let me ask you this. Y'all have another exhibit called T3.
T3.
T3, yes, sir.
Yes, sir. There'll be these individual pieces of paper.
Oh,
They were paper clipped to the back of your binders.
I have it. I have it. Thank you.
Is that in this book, T1?
No, sir. T3 and T4 represent the PowerPoint slides that are presented to the trainers and are provided to the counties as part of their training materials to provide training to their poll workers.
So the training provided to the trainers is what's shown by T3.
T3 and T4, those are PowerPoint slides that are given to trainers, and that's the material they're to use when they're conducting their training locally.
And that's actually in writing in their book, isn't it?
I don't understand that question, sir.
You said it was a slide. It's actually pages in their book, the trainer's book, that shows this.
I don't know about that. I know it comes from the PowerPoint presentation that we prepare and give to the counties.
Okay. I will say that if you look, ladies and gentlemen, at Exhibit E in the binder, the blue binder, Exhibit E, if y'all get to it. And so, Mr. Madison, I need you to do that too.
Yep.
Everybody there, I reckon. Looks like it. And that Exhibit E appears to be the same as your Exhibit T3 and T4.
Yes, sir. It appears that the PowerPoint slide presentation has been printed off with 2 slides per page. That's what this looks to reflect.
Okay. And this is the training that the trainers that you train are supposed to give to the poll workers.
That's correct.
Okay. And in looking at that document, Exhibit E or T3, T4, it says in there on the bottom of that page of Exhibit E of our brief, attempting to win votes by wearing or displaying buttons, and I'm going to skip some, or other articles designed to influence voters. Correct?
You read that correctly, yes, sir.
Yeah. And do you agree with that as being proper?
I believe that is,
Or do you disagree with it?
just a moment.
Sure.
So that is a restatement of the code section 71103 A8 II sub F, displaying or disseminating buttons, hats, pencils, pins, shirts, signs, or stickers containing electioneering information. And electioneering information is defined above as advocates for or against a candidate, issue, or measure on a ballot. So that's correct.
Okay, so what this says about designed to influence voters is correct in the law in this state.
Correct.
And I noticed at the top on Exhibit E, there's the first section talks about the display of or dissemination of information that advocates for or against any candidate, issue, or measure.
On a ballot, yes, sir.
Yeah. But it doesn't say the candidate on the ballot, right? Well, actually it does. It says on the ballot at the end.
It says, so I read that as advocates for or against any candidate on a ballot.
Yeah. And do you believe that Kamala Harris, who's running for president of the United States at the time of this election, you know that she was Joe Biden's vice president, right?
Yes, sir, I do.
And you also know that Joe Biden was running against Donald Trump, who was on the ballot, right?
Donald Trump was on the ballot, though.
Yeah, he was on there too.
Yeah.
And can you see how this button that's involved in this case would be a way of advocating, and I'm just quoting the statute here, for or against Kamala Harris, or that it was actually advocating for Donald Trump. You could concede that that could be the reason why this man got mad and he couldn't wear it.
I can't speak for why the man got mad. I can say that the button speaks for itself. It's one of the exhibits here. And I can also say that our training is it has to be related to a candidate on the ballot. And that's to provide a bright line rule.
That's what I was getting to, that bright line rule, because I remember you telling me that.
Yes, sir.
And is that bright line rule anywhere in this T1?
I read it as any candidate on a ballot.
Okay, is there any particular section in T1 in the poll workers book that tells them that it must be the person who's being depicted on the button must be on the ballot?
We cover that in the training, and then the statute itself refers to on a ballot.
Well, the statute, we make a legal argument for the commissioner's information about that.
Yes, sir.
And I'll let them read that. I kind of wish they'd gotten it yesterday, but they didn't. It's not the end of the world. I just want to know if there's any, just to make sure the record's clear, I'm not to belabor the point, but the bright line rule that you just gave us does not appear in T1, does it?
I think I've answered that question, and my answer is the term on a ballot is in the material on the notice of electioneering, and it's covered in the training. Now, does it say how I have phrased it in the training, those exact words? No, it does not.
Yeah, the bright line rule that you mentioned is not mentioned in this book T1, correct?
That is not what I said. I said
Okay.
it is mentioned in the book as the notice of electioneering, page 55, where it says on a ballot.
Okay, on page 55, Exhibit E at the bottom, it says anything designed to influence voters. It doesn't say it has to be a candidate on the ballot. It just says anything designed to influence voters. Do you see that?
Yes, sir, it does say that.
Yeah. Do you agree with that?
I agree that it says those words, and that's the terms of it, but it goes back to the definition of electioneering, which is on a ballot.
Okay. Just to be clear about it for the commissioners, in T1, I understand that you are arguing that you think it's mentioned as bright line rule. But is bright line rule mentioned anywhere in T1? Are those words in here anywhere?
Objection, asked and answered.
You're kind of beating a dead horse at this point, Mr.
You think it's dead? Then I'll move on.
I think you've asked it about a half a dozen times in a half a dozen different ways, and you're getting the same answer. And my guess is if you continue to ask it, you're still going to get the same answer.
I understand.
So I'm going to sustain the objection.
Okay. It will stand for what it is. For what was said. All right. Let's see here. I did ask about the advanced training, advanced testing on page, just a minute, let me get to it, on page 83
Yes, sir.
of Exhibit T1. And do you, as we sit here today, do you know of these test questions that include your question number 39 that you testified about? Do you know if that test was ever administered to Ms. Hammonds or Ms. Collins?
I do not.
And it may not have been.
I don't know.
Do you have any proof to that effect, that they were testing on that?
I have no proof that I have seen that they have taken those specific
Okay.
tests.
So the answer is I don't know if they've taken it or not. I got it.
I know they're legally required to attend the training, but whether they were tested on this or not, I can't answer.
A moment ago, we were looking at Exhibit 4.1, okay, which is in y'all's exhibits. If you'll turn to it, please.
Yes, sir.
Let me get to it. All right. I noticed in Exhibit D of the brief that I filed, if you would refer to that. D.
D is in David.
Yes, sir, or dog, either one. I noticed that the form that you have is Exhibit 4.1. That form is different from the form reflected by Exhibit D, which was a complaint filed by Mr. Ballard.
Yes, sir. That, as I testified a moment ago, there's two different forms that are used. If you look at binder 4.1, one that's titled State Board of Election Commissioners Official Complaint Form, and notice at the bottom it has a penalty of perjury above the signature. Whereas if you turn the page to 4.1, the second page, voter complaint form, that's signed by Mr. Ballard, this is the one that's used in the poll for complaints about voting equipment malfunctions.
Talking about Exhibit D.
And then Exhibit D in yours is an example of that voter machine complaint form. Yes, sir.
Are you aware that this is the form, Exhibit D is the form in the county clerk's office in Drew County for voter complaints?
It is a form that is provided related to machine complaints, and I would assume that it's in the Drew County Clerk's office. Yes, sir.
Yeah. We'll ask them about it when they testify, but one thing I wanted to lift up was the Exhibit D, the second paragraph. It talks about what they're supposed to do with the complaint form. And it doesn't say anything about contacting the SBEC, correct?
That is correct.
And would this be a Secretary of State form?
Yes, this form is promulgated by or published by the Secretary of State's office.
Okay. And did y'all use this Exhibit D form to take the complaint from Mr. Ballard?
No, sir. He submitted a complaint which is reflected in 4.1, the first page.
But he also submitted Exhibit D.
I assume so, yes, sir.
I mean, it's in your investigative file.
Yes.
Okay. I was just curious, you do recognize Exhibit D as the complaint that he filed, one of them, two of them, I guess, one in your book and the one in mine.
Yes, sir.
Yeah. Is the Secretary of State of Arkansas, are they the chief election officer for the state?
Secretary of State is the election official for the state of Arkansas. Yes, sir.
All right. Do you agree, Mr. Madison, that Ms. Collins and Ms. Hammonds may not have been trained to allow an electioneering voter to go ahead and vote, even though they're breaking the law?
I can't say as to how or what they were specifically trained. I can't testify to the training we provided.
And the only place, and I think I need to do this just to be sure, where is that red book? Yeah, hand me that red book, please, ma'am. Thank you. Other than on the last page of this 86-page book on question 39 you mentioned before, okay? Is there anywhere in this book for poll workers where it tells them that a person doing electioneering, violating the law, that they're supposed to go ahead and vote them? Your Exhibit T1 is what I'm referring to.
I understand.
Yeah, I know. I think I need to say that for the record. Is there anywhere in that book that it says that a person guilty of electioneering should be allowed to stay in the polling place and vote, even though they're breaking the law and maybe picking a fight, kind of like what you mentioned to me, these people with these buttons like what's involved in this case?
Not that could think of or identify in the moment, no, sir. But I do know it is part of the training materials that we provide.
And the only thing you can present to this board is on page 86, the last page of T1, that's in writing about that road.
No, sir.
Do you have anything else you want to submit on that?
Yes, sir. We submitted the T3 and 4 as the slides that are to be provided to the poll workers during their training, the lecture materials that we provide to the trainers, and where we cover this point specifically, the notice on electioneering refers to on a ballot. So, I mean,
Okay, well, let's go over them. Does T3 or T4 that you submitted as exhibits, does it say that you go on and vote a person that's electioneering and breaking the law?
no, sir, it's not in writing on those pages.
And so other than page 86 of Exhibit T1, one question 39, is that the only thing in writing about letting an electioneering voter go ahead and vote, or two, that they should vote that person?
I'm not aware of any other as we go forward, no, sir.
Nothing else in writing?
No, sir. I know it's covered in the lecture, but whether that's passed on or not, I can't testify to.
Yeah, correct. And that is one of the, you can't train all the poll workers. I know that, because you ain't got enough staff to do that. But at the same time, these ladies are here accused of violating election laws. And the only place they can find it in this book is question number 39 on page 86 of Exhibit T1. Is that correct?
As far as it being expressly written, I believe you're correct.
Yeah. And you don't even know, that's the advanced poll worker section of the test, right?
I believe it is, yes, sir.
And you don't even know if they took that part of the test. do you?
Objection. Asked and answered.
What's your response, Mr. Gibson?
I just was trying to ask my question, that there's nothing in writing in this material about that. I can move on. If he wants to object, it's
I think the
okay.
director's already answered that question, so I'm going to go ahead and
It's okay, I'm not objecting to that. All right, let's see what's next. Is there anything in this T1 or T3 or T4 that says if they have a problem with a voter electioneering, they're supposed to call your office?
Specifically related to electioneering?
Yes, sir.
I don't believe so.
Yeah. Is it appropriate to talk to the Secretary of State like they did?
That is one of the sources of information.
And you know they told the Secretary of State's office, told them, the Assistant Director, Mr. Josh Bridges, told these ladies in writing, and that's exhibit in our book, I think that's C. It is the email. Where he told them what they did was correct. Are you aware of that?
Yes, sir.
Did he violate the law when he told them that as one of the chief election officials in the state of Arkansas?
No, sir.
So he can tell them something is wrong and that they can be brought before this board to be, and the only word I can think of is prosecuted, because that's kind of what this is like. It's administrative, but it's kind of the same thing. You know what I mean. That he can tell them something wrong, and they rely on it. And
So the question I would have is,
I wasn't quite through.
I'm sorry. I thought you were finished.
I was rambling, and it was not a well-stated question, I agree. But the thing is, Secretary of State's office did that, and then on Exhibit E, I'm sorry, Exhibit D, as dog. If I can keep this straight here. Exhibit D, and I highlighted part of it, y'all. I was trying to point to the language. You saw that, didn't you, Mr. Madison?
I'm sorry, say that again.
Exhibit D is highlighted. So,
Yes, sir.
and in there, Mr. Ballard, this guy that's wanting to pick a fight, he said he talked to Secretary of State's office, and the First Lady said that it should not be an issue, that his button should not be an issue, you all be allowed to vote. And then he says in his complaint, soon after I received another call telling me the First Lady was in error and I could not vote while wearing the pin. And at that point, they referred, he says he was then referred to your office. You see that in his complaint there?
Yes, sir.
Okay. And the lady who told him wrong, you say he should have been, it was not electioneering, right? Just so the record's clear. And that he should have been allowed to vote.
Correct.
With that pin button, campaign button on.
Correct.
And that lady from the Secretary of State's office had called and said that the First Lady was in error and that he could not vote while wearing the pin. Is she guilty of an election violation as an election official?
I'm not exactly sure who is speaking to who in this. I'm not sure who the she is in this, so I can't answer that.
Did you investigate that to find out?
No, sir. I think what we did is we took the complaint that was filed with us and used that as the basis for the complaint because that's signed under penalty of perjury. And I haven't read it, so it could say that in there, but I don't recall it. I do know the original report addressed the Secretary of State's office and involvement in it, and it was dismissed as part of the original part of the investigation.
Right, I was gonna go to that. Exhibit H in my book, H. That's part of your staff report to this board, correct?
Yes, sir.
And in there, it says, and of course it's highlighted and it's there for the commissioners to look at, but in there, at the very bottom of that first page of Exhibit 8, it says the subsequent inaccurate information provided to the complainant by the Secretary of State's office, officials, was resolved with management at the Secretary of State's office. And it says, consequently, staff recommends,
I'm sorry, it says addressed, not resolved.
Mine says resolved. I'm not
The
sure.
bottom of the page in the footnote? I thought
Oh, no.
we were reading.
It's the last line of the big text.
If you carry over the next page, it does say resolved.
Yeah, all right.
It's okay. Was resolved with management at the Secretary of State's office. Consequently, the staff, and that's you, correct? Aren't you in charge of the SBE staff?
Yes.
That you recommended that that part of the complaint against that person who gave erroneous information, believing that it was electioneering material like these ladies did, you worked with them to be able to dismiss that complaint, make sure it didn't happen again, right?
Yes, I dealt with the Secretary of State's Director of Elections explaining, hey, this is an issue.
Right.
And it's one of the things we do pretty regularly.
Why didn't you do that with these ladies?
Because the information from the Secretary of State was several hours after the incident occurred. The Secretary of State's office officials, as far as I know, don't take specific oath as election officials. They're not required to attend our training like the poll workers are. The poll worker is the one that's on the front line, and the supervisor is the one on the front line that has the effect of whether the voter votes or not.
According to Exhibit E, I'm sorry, wrong one. According to Exhibit D,
He is in David?
yes.
Delta.
It says on that form that actually is in the county clerk's office down our way. And that form, which was provided by the Secretary of State, I understand now, says the complaint forms are to be forwarded to the County Election Commission for investigation. And a copy must also be forwarded to the Elections Division of the Arkansas Secretary of State. Now, it looks like the Arkansas Secretary of State has got both hands around these complaints by voters.
Yes,
Is
sir.
that what it says?
And if you look at the first paragraphs, it talks about be placed, the Arkansas Code 75510 requires county election commissions to provide to every polling place using voting machines, forms for voters to use in filling a complaint about the function of the voting machine. This is that form.
Okay. But this form is the one that Mr. Ballard made his complaint on, one of them.
One of them, yes, sir.
Yeah. And so you say this is only about election machines?
Yes, sir.
Huh. But it was used to give his complaint, I guess.
No, sir. I believe whenever we receive these complaints generally, big picture, if we
Sure.
receive this complaint in as a voter complaint form, we contact the voter and ask them to submit a complaint on our form so that it's signed under penalty of perjury. Because this form is not signed under penalty of perjury, and our rule requires that complaints filed with us be signed under penalty of perjury.
Okay.
So we send them the blank form so that they can fill it out and send back to us the correct form.
But I guess you saw Exhibit D first and said we need to use our form.
I don't recall specifically the sequence of it, but
Okay.
Mr. Gibson, are you close to wrapping up here? Because his direct was 10 minutes and your cross is getting into about 45.
Yeah, I took more time than him.
Okay, I understand that. But at the end of the day, Mr. Gibson, as I read it, it's a pretty narrow issue. Here's the issue as it's framed.
Well, wait a minute. Is it proper for you to characterize the issue for this board?
I'm not characterizing it, I'm reading what's in the order and notice of hearing.
Well, the notice of hearing I finally got last Friday. I had not seen it until then, and I'm not complaining about, I think I just messed up and didn't send it to me.
Well, this is the legal issue that the commission has to decide for today.
I have some issues.
Nothing about training, who to call, who was called, any of that. It boils down to this. The legal issue to be decided at this hearing is whether a button with the likeness of President Joe Biden displaying the words, quote, "Weak men create hard times," end quote, constitutes electioneering pursuant to Arkansas Code Annotated Section 7-1-103A8C-II, and whether it is proper or improper for a poll worker to prevent an individual wearing such a button from voting. That's it. That's the legal issue as staff framed it. The commission can't go beyond any of that. They're bound by the issue that's contained in the order and notice of hearing.
Well, I didn't get it till last Friday, and I will say when I first reviewed that document, there were things that we disagreed with.
But you've also got the stipulation, Mr. Gibson, and doesn't that kind of, you've stipulated to certain facts. Those facts seem to be related to the actual legal issue that's before the commission. Would you disagree with that?
They relate to it, definitely.
Okay.
There's no question about that. But I was just going to say that there are things that are said in that notice of hearing that we don't necessarily agree with. But when you get them last Friday afternoon before this hearing, it's impossible for me to include that in my brief. I just want the commission to know that. And I'm not sure it accurately states it. But the thing that I was getting at, I was trying to actually finish my examination when you interrupted me, but it's okay. It's not the end of the world. Now, there are 2 or 3 questions I'd like to ask Mr. Madison. As I appreciate it, you do not question the good faith of Ms. Collins and Ms. Hammonds, and you believe that they were trying to do the right thing.
Absolutely.
And you, in fact, told me that you don't have anything against these ladies. They're salt of the earth, good people.
As far as I know, yes, sir.
And I also understand that you believe Mr. Ballard, this voter, was trying to pick a fight by wearing the Biden button.
I don't know if I believe he was trying to pick a fight. I may have said that as a way to diffuse our conversations, but when we talk about it, it is my experience that people that wear pins like this are often looking to create some controversy.
Yeah. And last question, Mr. Madison, do you agree that this board has the authority to dismiss the charges against Ms. Collins and Ms. Hammonds, just like it did for the Secretary of State?
It has the authority to take any of its actions available to it. Yes, sir.
Okay. I can't think of anything else. Do y'all know anything? Mr. Madison, thank you for bearing with me. I didn't do the best job, and my voice is not real good, but I think we made it through it. Thank you.
Thank you, Mr. Gibson. Mr. Kendricks, any follow-up for the record?
No, sir.
Commissioners, any questions?
I have a question. Mr. Madison, counsel for the election commissioners, has consistently referred to this regarding what happened as dealing with someone who was electioneering. Is it your understanding that what the board said was that they were not, the person was not electioneering?
That's correct.
Thank you.
Any other questions from the commission?
I have. Recommend. You indicated in here that if you had a hat, MAGA, that would not be allowed. That's a slogan. How do you define a slogan?
It relate.
It's a logo.
It's a logo that's identified with a candidate on the ballot, and that's one of the examples.
So if I had a hat that said "Create hard time," weak men create a hard time. That's a slogan. That's a logo. That's allowed.
That would be
That's election.
That would be allowed. So like this
MAGA is,
electioneering.
and this would not.
That's correct.
If it was on hat.
That's correct.
Why?
Because that has, one, if that had the image or likeness of a candidate on the ballot and it made that comment. So say, for example, Mr. Biden, President Biden was continued on the ballot and that come in, then it would relate to a candidate on the ballot.
I agree.
If it does not have the candidate's image on there, that's not a slogan that's necessarily associated or posted by the campaign of Kamala Harris or Donald Trump in the election. So it has to be related to a candidate.
Is there a list somewhere of these slogans that proscribe somehow?
There is not a list, no, sir.
If somebody walked in with the image of an elephant, is that electioneering?
Is it related to a candidate?
Is it for or Republican?
I wear a red tie.
Okay. I'm just asking those kind of questions. But slogan, and I understand slogans can be inflammatory sometimes.
It can't be.
How do we know that this is not a slogan? Same as MAGA, just not as.
So
What candidate was using it?
As MAGA.
None.
Okay. If I wore a MAGA hat.
That is,
True. Yeah, I
That
know,
is-
and you know, but is specifically saying, make America great with Donald Trump? No, it's not saying that. It's just make America great.
you're
Again.
way off the subject.
No, we're not off the subject, because this is what they're looking at, right here. They're looking at this,
Right.
and they're seeing electioneering. They're seeing the head of the Democratic Party.
Who's
and
not
they're
on the
seeing-
ballot.
I know that. Please.
Read the law.
Please, let me continue.
Commissioners,
You're the smartest person in the room, I understand that, but just let me finish. I see weak men create hard times as a slogan. I see Joe Biden's picture on there as a head of the Democratic Party. I see this as somewhat of I'm going to make a statement in here when I vote. And when he was asked to take it off, he was angry, grabbed his ID back, and walked out. That's telling me he was trying to make an issue out of it. And if I was kind of confused when I'm looking at this, certainly they were confused about when they were looking at this. And what I don't really understand is how, as the Secretary of State's office, if they're confused, I'm confused, there's a lot of confusion around. Okay, that's all. I just had a question about the slogan part. Okay, so there's no list of acceptable or unacceptable.
No, sir.
Judgment call.
And that's partly why when we do the training, we discuss it as the bright line rule as a candidate on the ballot.
And can't possibly cover every situation.
No, not at all. And some of it is exercising discretion, but the other issue is, that's why we also say, if you believe someone's engaging in electioneering, you go ahead and vote. And that's part of the problem here, is that this person did not get to vote in that initial circumstance. And had to.
Am I wrong in assuming, about what I've read here, they didn't even get to that point to give him a ballot? He got angry, he pulled his ID, and he walked out. So, did they not allow him to vote, or did they just kind of too slow to give him the ballot? I mean, and this is where I read this. It's like, he got angry, he left. How is that denying him the opportunity to vote?
There's no easy way to answer that. I wasn't there. The investigation found that a person came in with that pin on. The initial question is whether or not it's electioneering or not. And under the training, staff has taken the position and written the report that it is not electioneering. So the initial conflict over the electioneering was improper, because the training is that this doesn't relate to a candidate on the ballot. Secondly, the person became upset, and part of and this is in the dealing with election day problems, voting in the poll problems, training section. And the process is for electioneering, even if they are completely electioneering, you vote them and get them out. If they're not electioneering, you vote them, because you're denying someone the right to vote, and that's the position we take.
Were they given the opportunity to give him a ballot?
I'm sure they will testify to that on their side.
I have one more quick question. What was the size of the pin he was wearing?
I think it's reflected in the report, it's 1.5 inches or so.
So not like the picture that we have?
No, it was like a smaller one, but I understand it.
Thank you.
Any other commissioners?
Mr. Hearing Officer, I have one more question I need to ask, if you'll permit it.
All right, please proceed, Mr. Gibson.
Thank you. Going to what's been asked and answered with the commissioners, Mr. Madison, if at the congressional elections in 2026, there are going to be a lot of congressmen and so forth running, right, for Arkansas.
Every congressman will be up in 2026 or up every 2 years.
And would you agree with me that it's likely that President Trump is likely to endorse one or more of them?
Sure.
Okay. I would think so too. But if someone came in the polling place with a button that had the likeness of Donald Trump on it, and at the bottom said convicted felon, would that be electioneering?
In the 2026 cycle?
Yes, sir.
No, sir.
That's the question I had.
Well, thank you, Mr. Gibson. Mr. Hendricks, any questions from you?
We have no further questions.
Do you rest, sir?
We rest.
Director, thank you very much for your testimony.
Thank you.
Commissioners, you've been going for a little more than an hour. Does anybody need a 5-minute break just to stretch, or?
I need
Yes,
a brief,
sir, restroom?
brief break. 5 minutes.
5-minute break? All right, we'll go ahead and go off the record.
There may be a
Chairman,
line.
5 minutes is ended, so.
I'd like to make a statement, just as Commissioner Thomas.
Sure.
It pointed out to me I made a disparaging remark for the fellow commissioner, and I wanted to apologize for that.
I'm not certain what the disparaging remark was, Commissioner, but I assume the rest of the commission appreciates, as well as staff, your apology. Thank you. All right. Mr. Gibson?
Yes, sir.
Yeah. Ma'am, would you be so kind as to raise your right hand? Do you swear or affirm the testimony you're about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you very much, ma'am. Mr. Gibson?
Thank you, sir. State your name, please.
Sherry Collins,
And what is your address?
393 Route Road, Monticello, Arkansas.
Okay, lean up toward that thing. I'm not sure it's coming through. Is the light on?
It
Yes,
is.
sir. Yes.
Good.
It's loud. Yes, sir.
And Ms. Collins, would you tell the board how long you have resided in Drew County, Arkansas?
Most of my life.
Okay. I'm not going to ask you your age, but it's a long time you've been there, I reckon.
Yes, sir.
Okay. Would you tell the board how long you have worked in elections in Drew County?
Approximately 20 years.
Okay. And during that 20 years, have you ever been cited or accused of violating any election law during that 20-year period?
No, sir.
Is this the first time?
Yes, sir.
All right. And I now need to move toward what happened that fateful day, October the 31st, 2024, when a man named Terry Ballard came in there into the polling place. Were you working that day?
Yes, sir.
Was that the early voting?
Yes, sir.
Okay. And I take it there were other poll workers in there too.
Yes, sir.
About how many?
I think it was 6 of us.
Okay. And if you would, tell the board what happened that day that starts this whole thing going.
Mr. Ballard entered the polling place there at the Drew County Courthouse.
Did you know him?
No, sir.
Okay.
Never met him.
Okay.
He came into the polling place. He gave his ID driver's license to the poll worker clerk so he could be checked in to vote.
Who was that?
The poll worker clerk,
That took the driver's license?
Vicki Eagleston.
Okay. And, okay, go ahead. Tell the board what happened.
I noticed the pin campaign button on Mr. Ballard's tie, and I told Vicki, the poll worker clerk, to wait. And I told
I'm going to interrupt you just to be sure this is clear. Like my tie, he was wearing it on there like this?
Yes, sir.
Okay.
Where it could be seen.
Okay. Go ahead.
I told Mr. Ballard that he would need to conceal or remove the campaign button pin because it was electioneering.
Okay.
He said that it had nothing to do with voting. And I said, well, the image picture of Joe Biden with the words, "Weak men create hard times," was the reason that he needed to conceal or remove the campaign button pin from his tie.
Did you think he was trying to influence voters?
Yes, I did.
Okay. And so what happened then whenever you told him he had to take it off or conceal it?
He became frustrated. He then snatched his ID driver's license,
Snatched it?
yes, from the Vicky's.
Show us how he did it.
He just grabbed it like that and jerked it out of her hand.
Okay.
And he stormed out of the polling place angry.
Angry, you say?
Yes, sir.
Okay. All right. What happened next in your involvement in this matter?
Well, I waited several minutes before I went up to the code.
Why did you wait?
Before I went to the county clerk's office, because Mr. Ballard was angry when he left. And I didn't want to encounter him in the hallways as I was going to the county clerk's office where Michelle Hammonds was.
Okay. So you waited and then you went to the county clerk's office?
Yes, sir.
Tell the board what happened when you got there.
When I got to the county clerk's office, Michelle Hammonds was in the process of emailing Mr. Bridges at the Secretary of State's office about the incident.
She told you that? That's what she was doing?
Yes, that's when I
Okay.
found out that Mr. Ballard had already been to the county clerk's office.
Okay, you found that out too, I guess?
Yes,
Okay,
but I told Ms. Hammonds what had happened downstairs
okay,
in the polling place. How Mr. Ballard had the pin on, how he refused to remove it or conceal it, and that he had left angry.
okay. And what else happened? Anything else?
Michelle states that she agreed with my interpretation of electioneering and how I conducted myself in front of Mr. Ballard. And then at that time, I left downstairs to the polling place.
You went back to work?
Yes, sir.
Okay. All right. At any time, well, strike that. I want to go on forward. When was the next time you heard anything about a problem with Mr. Ballard?
Later on in the day, Michelle came downstairs to the polling place and said that she had received an email or information from Mr. Bridges at the Secretary of State's office, and that we, according to him, had done correctly.
I won't bring something up to you, okay?
Okay.
And I take it you've seen that email,
Yes, sir.
and that's Exhibit C in my packet.
Which,
C? Yes, sir. And is this the email that Mr. Bridges sent, where he said what y'all done was correct?
Yes, sir.
Okay. And, so you learned that, and what happened next?
Well, later on in the afternoon, Michelle came down to the polling place and said that she has received word from Mr. Madison, the SBEC director,
Yes, ma'am.
that we were wrong, that we needed to allow Mr. Ballard to vote with the campaign button on.
And so did you and Michelle arrange for that to happen?
Yes, sir. We thought he was coming that afternoon. I instructed the other poll workers that were working with me that he would be coming and that we were to treat him with respect.
And was he going to be able to wear his pin?
Yes, yes, sir.
And
And they were not to say anything about it.
And tell us what happened.
Well, he didn't come that afternoon. He came the next morning.
Okay, go ahead.
I received word from someone in the county clerk's office that Mr. Ballard would be coming to vote, and he would be escorted by Stephanie Chisholm, the county clerk,
The head county clerk.
the head county clerk. Yes.
Okay. And what, so go ahead, tell the board what happened.
Well, after I received the information, I told my fellow poll workers that he would be coming down with Stephanie Chisholm. I myself took myself to the back part of the polling place, so there would be no interaction with Mr. Ballard and he came in with Stephanie Chisholm, presented his driver's license ID to, I believe it was Vicki Eggleston. She checked him in, and he was processed, and then he went on and voted without any trouble from the poll workers, and then he exited the polling place.
Okay. And that was the end of your contact with that man.
Yes, sir.
Ms. Collins, at any time, from the first time you ever saw that man until the last time you saw him, did anybody on the Drew County polling workers treat him with disrespect at any time?
No, sir.
Say anything ugly to him? Anything
No, sir.
out of place?
No, sir.
Okay. Well, look here, I think I'm about through, okay? Just hold on a second. Oh, you know, when Mr. Ballard first came in to vote
Yes, sir.
the first time, and you told us about him getting angry and snatching the license and leaving, did anyone at any time ever tell him he could not vote?
No, sir.
Okay. All right, that's all the questions I have.
Thank you, Mr. Gibson.
Mr. Kendricks may have a question.
I have just 2 questions.
Yes, sir.
First, you did receive the required poll worker training prior to working the early vote?
Yes,
correct?
I received training.
Okay. And you took a test at the end of that training?
I took an exam at the end of the general poll worker training.
Okay. That is all.
Mr. Gibson?
On that issue of training, you heard the questions I asked of Mr. Madison. Take but a second to cover those. Have you ever been trained on a bright line rule that if a candidate is not on the ballot and that not on the material, electioneer material, button or whatever, that it took the candidate on the ballot had to be on the button in order to for it to be electioneer material. Did anyone ever train you on that?
The bright line rule, no, sir.
Okay. And has anyone ever trained you on where the voter is electioneering? That they still should be allowed to stay in the polling place with their electioneering button material displayed and be allowed to vote? Has anyone ever trained you that way?
No, sir.
Has anyone at any time ever trained you that if there's a problem like this that's happened in this instance, that if you have a problem that you're supposed to contact the State Board of Election Commissioners as opposed to the Secretary of State?
No.
Okay. That's all the questions I have. Jonathan may have another question.
Mr. Kendricks? Thank you, Mr. Gibson. Mr. Kendricks, any other questions?
We have no further questions for this witness.
Thank you, sir. Commissioners, any questions?
I have a question.
Yes, ma'am.
Good morning. You testified that you have been working in elections for over 20 years. Is that correct?
Local elections.
Right, in Drew County,
In Drew
correct?
County.
All right. And you're aware that it's your responsibility as a poll worker to have an understanding of the rules and the law that are to be followed during the voting. Is that correct?
To the best of my knowledge, what I've been trained with is what I go on, yes.
Okay. And when Mr. Ballard came in to vote and you saw the pen and told him he would have to take it off, his reaction to that and his leaving kept him from voting that day, right?
Well, I look at it this way. He chose not to vote.
Okay, that's not what I asked you. I said, let me put it this way. He was in the process of doing what he needed to do to be able to vote when he came in. Is that correct?
He presented his
Right.
ID, yes, and I
Okay.
told the poll worker to wait.
Okay, so you interrupted that process, correct?
Yes, ma'am.
Okay, and by interrupting it, it kept him from voting because he chose to leave after what you told him, correct?
Right, but I thought it was my responsibility that if I saw an electioneering and they had not officially been checked in, that I could call attention to it.
Right, what you thought was electioneering, but it was not electioneering, correct?
Well, in my way of seeing things, it was electioneering because I thought he was trying to influence voters in the polling place.
But Mr. Biden was not on the ballot, correct?
That is correct.
Thank you. I have no
Yes, sir.
further questions.
Ms. Collins,
Yes, sir.
you now understand that that was not electioneering based on the law.
The way you're telling it, yes, I see your point, but at that time,
I'm not talking about that time, I'm talking about right now, in black and white, the law says you have to be on the ballot.
yes, sir, I see what you're saying, yes, sir.
Thank you.
Any other commissioners? Ma'am, thank you very, very much for your testimony.
Thank you.
Next witness, Mr. Gibson.
Ms. Michelle Hammonds.
Do you swear affirm the testimony about the given this hearing is going to be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you so much. Have a seat, please. Mr. Gibson.
Sure. State your name and address for the record.
My name is Michelle Hammonds. My address is 158.5 West College Avenue, Monticello.
Okay. And how long have you resided in Drew County?
About 35 years.
Okay. And I understand that you are a deputy clerk in the county clerk's office. Is that correct?
Yes, sir, I'm the executive deputy.
Executive deputy. And how long have you been there?
Almost, it'll be 10 years in September.
Okay. And have you held the same position the whole time?
No, sir, I started out as the accounts payable clerk, and then I moved up to payroll, and then I became the executive deputy.
Okay. And in your tenure, how many different county clerks had you worked for?
I worked for the line of Gullidge, which was the elected county clerk that hired me. And then I worked for the interim county clerk, Nancy White, that filled in when Miss Gullidge left. And I'm now working for Stephanie Chisholm.
Okay. And Miss Chisholm's here today, is she not?
Yes, sir, she is.
And have you ever been cited or accused of violating an election law?
No, sir.
In the 10 years you've been there?
I'm sorry, no, sir.
Have you worked with elections every year that 10 years?
Yes, sir.
And tell us what positions you've had.
When I first started in the county clerk's office, my very first day, they had me downstairs observing a school board election to see how it went, just to kind of see the procedures and the policies that everybody followed during the school election. And then I've been over the early voting site at the courthouse since Miss Gullidge was the county clerk.
Okay. And have you been provided with training during that time?
Yes, sir.
Tell the board about that.
We're trained by our local county board of election commissioners. We do the general poll worker training.
Okay. Have you ever heard of a bright line rule that a candidate on the ballot must be depicted on a button or their name for it to be considered prohibited electioneering?
Not until recently.
Not until this case?
Yes, sir.
Okay. And have you ever seen anything in writing in any training materials that tells you that?
No, sir.
Have you ever heard from your training that a voter who is electioneering, which you're not supposed to do, should still be allowed to stay in the polling place and with their electioneering material displayed and be allowed to vote?
No, sir.
Prior to this incident, or prior to Mr. Madison calling you one day, we'll get to that, has anyone ever in any training, wait a minute, let me rephrase my question. It's made me think of something else. Who are you supposed to call when you got trouble?
We've always contacted the Secretary of State's office. That's what I was told to do.
In the beginning?
Yes, sir, by the county clerk I worked for.
Yeah. And tell the board what kind of contact you have with the Secretary of State's office in doing elections.
They are the ones that contact us. They're the ones that put out the election calendar. They contact us with deadlines, paperwork, multiple things. Pretty much everything we get from elections, we get from them.
Have you gotten anything ever from the SBEC?
No, sir.
All right, let's move on to Mr. Ballard. Tell me what you know about Mr. Ballard on October the 31st, 2024.
The first contact I had with him that day is when he came upstairs to the county clerk's office. I knew him previously. He was a sheriff's deputy for our county for a while, so I knew who he was when he walked in the door. He said he had a complaint. I looked at him as he said that and noticed the campaign button that he had on his tie. I asked him what happened. He told me what had happened, and I asked him would he remove his pen or cover it up. I offered him some tape to cover the pen, and he refused to do that. He didn't want to do it. So he asked who he could. I explained to him that I agreed with what the poll worker had told him, and he asked who he could contact besides us, and I directed him to the Secretary of State's office.
And told him to call the Secretary of State. Did you give him the number?
No, sir, I don't believe I did. I don't remember.
But that's who you told him he needed to call?
Yes, sir.
Okay. And what was the next thing that happened?
The next thing that happened was I went back to my computer and I sent an email to Mr. Bridges, the Assistant Director of Elections at the Secretary of State's office, explaining to him what happened, to see, and told him that we thought it was electioneering, to see if he agreed with us or not.
Did he agree?
Later on, I got a response that yes, sir, he did.
Good. All right. And did you share that with Ms. Collins?
Yes, sir. After I got the email, I went downstairs and told her.
Good. What happened next?
The next thing that happened was the election coordinator, Miss Nancy White, walked up to me and said, Chris Madison is on the phone and he wants to talk to you.
Okay.
And she handed me her cell phone. I had heard the name, but I didn't know exactly who he was. She said he was with the SBEC, which I knew what those initials stood for because I had heard of it before.
Okay.
I took the phone. He asked me what happened. I explained to him what happened. He told me that we were wrong, that it was not electioneering, and that he should be allowed to come, that he had told him to come back later that afternoon. And
Talking about Ballard?
Yes, sir. That
Okay.
he told Mr. Ballard to come back later that afternoon, and that he could wear his pen, and that we were to let him vote.
Okay, and what did y'all do to arrange for him to vote?
I went back downstairs and I told Ms. Collins, there were people in the poll site, so I didn't speak directly to all the poll workers.
What'd you tell her?
I told her that I had just gotten a phone call from Mr. Chris Madison at the State Board of Election Commissioners, and that he said that we were wrong, that it was not electioneering, and that Mr. Ballard would be back later that afternoon to vote, and that he could wear his pin.
Okay. And Ms. Collins and you had it arranged for him to come vote
Yes, sir.
with his pin on?
Yes, sir.
All right. Did he come?
He did not come that afternoon. He came the next morning. He came to the county clerk's office, and the county clerk, Miss Stephanie Chisholm, said that she was going to take him down there so he could vote.
And you were present for this?
Yes, sir, I was there.
Okay. Go ahead.
She then went with him down there to vote. After they left the office, I called Miss Sherry Collins on her cell phone and told her that they were on their way down there to vote, and reminded her that he was going to be wearing his pin. He was wearing it, and it was okay for him to go ahead and vote with his pin on.
Okay.
And then I didn't have any contact with him after that.
Did he vote?
Yes, sir, he voted.
All right. At any time, was anybody disrespectful to Mr. Ballard?
No, sir.
Any bad words, any cross things, nothing like that?
No, sir.
Okay. All right. I think I'm about through. Hold on just a minute.
Yes, sir.
We've been talking about bear with me. Exhibit D to me in my brief package.
Yes, sir.
Are you familiar with that document?
Yes, sir.
Have you seen one of those forms before that had not been filled out?
Yes, sir.
Where?
We have them in our office, and they're also in the binder for the poll workers at each polling site.
Okay. And I noticed on there it says something about what you're supposed to do with complaints.
Yes, sir.
And what does that, that's in your office, and what does it say to them?
That the poll workers must forward the complaint forms to their county election commission for investigation, and a copy of the complaint must also be forwarded to the elections division of the Arkansas Secretary of State.
Doesn't say anything about SBEC, correct?
No, sir.
And let me ask you this. Do you know where Mr. Ballard got this form?
No, sir.
But that is the official form in your office
Yes, sir, it is.
to be used on complaints.
Yes, sir, it is.
Okay. All right. And I guess you told the head county clerk about what Mr. Bridges said about y'all being correct, what you had done.
Yes, sir, I did. She was the first person I told.
Okay. And let me ask you this. Did Mr. Bridges ever suggest or say that you ought to call the SBEC?
No, sir.
I didn't see it in his email. That's Exhibit C to our brief that's been admitted. Are you aware that the Secretary of State's office suggested that to Mr. Ballard that he contact the SBEC?
No, sir, we didn't. I didn't actually get a copy of his complaint form until several months later into this investigation, and I had not seen that until then.
But you've seen his complaint, Exhibit D.
Yes, sir, I have.
And there it indicates that he signed it as he And then it was referred to the SBEC.
Yes, sir, I saw that.
If anybody had ever suggested that you contact the SBEC about this problem instead of the Secretary of State, would you have done that?
Absolutely.
And do y'all try to follow all the rules to the best of your ability?
Yes, sir, we do.
And have you had 10 years worth of good work out of Ms. Collins as a poll worker?
Absolutely.
Okay.
Couldn't run early vote without her.
Okay. I think I'm about through just a moment. I guess if the Secretary of State had recommended y'all contact the SBEC, that y'all would have contacted them and the problem would have been solved and we wouldn't be here today.
Yes, sir.
Okay. Would you like for the rules on electioneering, the bright line rules, all these other rules that are verbally delivered in a training that you don't go to, would you like for them to be put in the books and the training materials?
Absolutely. If it's a rule we need to follow, we need to know about it.
Okay. That's all the questions I have, Jonathan.
Thank you, Mr. Gibson. Hendricks?
Ma'am, you stated that you were over the early vote site. So were you in a supervisor role?
The county clerk's office is over early vote, so yes, sir.
Okay, so you were the supervisor.
Yes.
And you did receive all the required training to be an election official prior to the early vote beginning, correct?
I received the general poll worker training, yes, sir.
And then was T1, Exhibit T1, was that in the poll? A part of the poll material, the materials provided to the poll?
No, sir, we don't supply that poll worker training book to the polls.
Okay, so your CDEC didn't provide that to the poll either?
To my knowledge, we didn't, there wasn't one downstairs.
That is everything that I have. No more questions.
Mr. Gibson?
No, sir,
follow-up?
thank you.
Commissioners, any questions?
I have one.
Yes.
Although I think this is very peripheral, I'd just like to have it clarified in the record. Exhibit D, it states at the top, voter complaint form. And the first sentence in it states, thank you.
Yes, ma'am.
The first sentence states, Arkansas Code annotated section 75510 requires county election commissions to provide to every polling place using a voting machine forms for voters to use in filing a complaint about the function of a voting machine. Do you agree with me? That's what it says?
Yes, ma'am.
So this form is specifically to be used if there's a problem with a voting machine. Would you agree with me on that?
Yes, ma'am, I agree, that's what it says.
Okay. And it also has a place for the voting machine identification number at the bottom and the poll where it's located. Is that correct?
Yes, ma'am, I see that.
Okay, so the fact that he filed this form before he filed the complaint, the appropriate complaint form with the SBEC doesn't really matter, does it?
No, ma'am.
Thank you.
Commissioner?
That was the question I had, but I had one follow-on.
Yes, sir.
Do you have the State Board of Election Commissioners official complaint form in the poll sites?
No, sir, we do not.
I have a question.
Commissioner?
Good morning.
In your answer, you stated specifically that you'd taken the general training. Does that mean you have not taken the advanced training?
No, sir.
Okay.
No, sir, you have not taken the training, or no, sir, it doesn't mean that.
Have you taken the advanced training? Or the advanced poll workers training?
No, sir.
Okay, thank you. On the email that came back from Mr. Bridges, as you read through, I see what's highlighted, section IA8. In any of this section, does it indicate anything that the complainant, any violation that the complainant may have made?
I don't understand the question.
Section C of,
I've got one.
yeah,
What exhibit are you looking at, Commissioner?
I'm looking at exhibit C.
C?
Yes, sir.
I'm sorry. Yes, sir. I have it.
For the gentleman that voted on any of the responses, were any of these in violation? Or the gentleman that wanted to vote, that Mr. Ballard, sorry.
I'm sorry. I'm not understanding what you're asking me.
Question was asked to the Secretary of State's office, who sent in return the rules around electioneering. Did the complainant violate any of these rules listed?
In the electioneering law,
Yes. The midsection on the page that's highlighted in below, specifically what electioneering means.
I believed that he did. Yes, sir.
Which one, can I ask?
Any other questions from the commission?
Okay, thank you.
That's fine.
I'm sorry, Commissioner Williams, you had a question pending, right?
Yes, sir.
Okay.
Not the way this is written. No, sir.
Thank you.
Any other questions from the commission?
Commissioner Brooks.
I'm sorry, ma'am?
That's Commissioner Brooks.
Commissioner Brooks,
Sorry.
have you all been to any of the trainings around the state that the SBC put on?
No, ma'am.
Have you all been to any of the county clerks training or continual ed?
Yes, ma'am.
Okay. No other questions.
Thank you. Anything else from the commission? If not, ma'am, thank you very much for your testimony. Mr. Gibson.
That
you're up.
concludes our case.
How about closing statements, Mr. Kendricks?
Yes, sir. Staff would like to ask the board to find that we have sufficiently established that a violation of election law has occurred, and to consider imposing a sanction of a letter of caution with a requirement for the respondents to attend training at the SBC office at a time of choosing by the SBC director, based on the confusion and lack of knowledge on the Bright Line rule and the SBC training that is provided to the trainers, as demonstrated by the testimony given by the respondents today. They have testified that they did not understand the training that the trainers received. This is a request to alleviate them of that confusion.
Thank you, Mr. Kendricks. Mr. Gibson?
Yeah, just very briefly, I really wish y'all had gotten this brief before today, and because it is a little bit lengthy and it's got several exhibits, but you didn't. And you'll have to decide how you want to proceed on that. But in the stipulation, the state SBC has stipulated that he believes that these ladies acted in good faith. They tried to do the right thing. There's no dispute about any of that. This is a technical violation, if it's a violation. Actually make an argument in my brief that I would like for you to consider that the Biden button was electioneering, flat-footed, under the rules that are there. And I make those arguments, and my voice is not capable of repeating all of those, okay? But I've spent a great deal of time on that. That doesn't mean you have to look at it, but I'd like for you to. I'd like for you to consider it. And frankly, in this kind of situation with all the, I think the word was from a commissioner, all this confusion about this is not a proper thing to do, to issue a letter of caution to somebody that makes them accept that they knowingly violated election law. That's heavy-handed in my judgment. And I ask you to consider something that might remedy the problem. Issue a letter of instruction to every poll worker in the state and put in writing the bright line rule, the rule that they get to vote anyway, the rule that they need to call the SBEC, not the Secretary of State. And give everybody a fair chance at knowing what the dadgum law is. These ladies did the best they could, and they should not be in any way condemned or made to accept that in some way they knowingly violated an election law. I know that's what Mr. Ballard wants, and he will have succeeded in picking a fight if anything is put against this lady. These ladies, two of them, trying to do the best they could, never been in trouble. And I've said enough. I thank you for your attention. I do appreciate it very much.
Thank you, Mr. Gibson. At this point in time, the commission is going to start their deliberations. They're going to go ahead and do that on the record. I guess I will turn it over to whoever the chair is to initiate those deliberations.
All right, sure. Thank you, sir. I just want to reiterate, we're on the record, so we are going to have to speak one at a time. So I guess any of the commissioners would like to speak first. Sir, Commissioner Luther.
I want the commissioners to consider this. When you look at the hearing, legal issues raised in this complaint, poll worker improperly, emphasis on improperly, turned away by a voter for electioneering because of the button he was wearing. Then if you'll please turn to the stipulations page. Item number 6, following this, Terry Ballard became frustrated and angry and snatched his ID from another poll worker, and emphasis voluntarily left the polling site without voting. And then if you will turn to the complaint, SBEC complaint.
Commissioner, which section?
That is in section 4.1. I apologize.
Thank you, sir.
The last two sentences of the complaint. I contacted your office, SBEC, Director Madison, and was instructed I could vote wearing the pin. I voted this morning with no issue. I feel that the voter was not improperly turned away. He was not told to leave. In his anger, he voluntarily decided to leave. Now, that prevent him from go voting, but he ultimately did vote the following day.
Right, but, and I agree with everything that you said, but I think he would not have become angry and left had he not been told inappropriately that he could not vote wearing the pin.
Okay, I'd have to ask you, how do you determine what was going to make him angry or not going to make him angry?
I'm not saying that. I'm saying what did happen. I'm not speculating about what might have happened. I'm saying what did happen was He was in the process of handing in his ID so he could vote there. He was interrupted and told he could not vote because he was wearing that pin, which was not accurate. Had that not happened, we don't know of anything that would have kept him from going forward.
Speculation of what you got angry about. So if he would have been left in line for an additional 2 or 3 minutes and became angry and stormed out.
We don't know that he was in the line.
That he became angry and stormed out, would that have been hindering?
I don't know
his
because that
ability to
didn't
vote?
happen. That didn't happen.
No, that didn't happen. He was told.
I'm just talking about what did happen.
Okay. Did you finish?
Yes.
Okay.
Commissioners, y'all, this side of the room, do y'all have anything to add?
The only thing I would add is, I don't think it's as clear cut that, this button was not electioneering. I think you can argue about electioneering. I've heard some statements that it's a bright line rule. If it's that much of a bright line rule, I think we need to have it bright lined in our rules a little better. I'm all for a letter of instruction on this and moving on.
I would agree.
And I think the one thing, I'm sorry, you want to go ahead?
I was going to suggest added to that is what Mr. Kendrick added after the letter of caution about the instruction to Drew County election officials and training, mandated training.
Right, I think the one thing that we can all agree on here today is more training is necessary. That it wasn't clear, at least in Drew County, maybe other places, about what they should do in this situation. And I think that the letter of caution was appropriate. I still think it's appropriate, but I'm not fixated on that. But I do think, in addition to the training, I think one thing that has come out of this that the board should do is make it clear to the clerks and the election commissions that if it's not a voting machine, the right form for a complaint is the State Board of Election Commissioners form. And those should be available through the commissions and the clerk's offices.
Commissioner Williams.
In my mind, that issue is, it was determined that this was a potential electioneering violation. At the point that anybody working in a poll determines that, we need to be able to point specifically to the statute that calls that out. And while I understand he left of his own accord, at the point that he felt he could not vote, he made that choice. That's fine. But if we believe that it is electioneering, we need to know explicitly what it says so that we can make that determination quickly. So through the process, this was not on hand and available.
Right.
The information upon email to Mr. Bridges that came back did explain what it is and what it isn't. And because what the gentleman was told was not explicitly enumerated here, I don't think it was appropriate to say that it was electioneering. I say that without regard to whether it's a letter of instruction or caution, but specifically, the statute didn't say expressly deny what was happening. So I don't know that it could be accurately called electioneering. And from that standpoint, that's what I take issue with, was there wasn't anything very, very clear to point to, and explicitly in the training material it says on ballot. And so from that perspective, Mr. Biden was not on the ballot, and as a result, that would not be electioneering. Additionally, a couple things. I would recommend not having a section on general and advanced. If it's training that they need to take all of it. And then a refresher with clarity specifically on the rules around this. I don't see bright line stuff in there. That may be common legal terms. I'm not a lawyer, I do not know. If there is a clear standard that we wish to enumerate, it needs to be called out in the training, as well as in the content and the material, to make sure that it is explicit, so that individuals working these locations have something very clear to refer to.
And they have to have it in the poll.
Yes. Agreed. Thank you.
And I'll just make one comment from the chair, because I think I don't know, it might guide the board's decision or be relevant to it, but there was a comment made about the letter of caution, meaning, in my understanding of what council was saying, meaning that the board's letter of caution has said that the ladies had knowingly violated election law, and I don't think that that is what the letter stated. There's a purpose section that says the letters inform you, I'm jumping ahead, that your decision was incorrect and resulted in a violation of election law. It goes on to say, if you have any questions, reach out to SBC. The board thanks you for your cooperation with this inquiry and recognizes the substantial efforts you've made to serve the community as an election official. So I think that is a distinction. I think those are two pretty different things. And
I agree with you. Knowingly is not an element of it. And a letter of caution means a written disposition of an allegation against any person which is advisory in nature, clearly giving notice to the respondent that his or her action or lack of action is a violation of law. And the letter of instruction means a written disposition of an allegation against an election official or county clerk issued in furtherance of the State Board of Election Commissioners' responsibility to provide training for election officials. A letter of instruction may be issued when the State Board lacks authority to adjudicate a complaint, when the board makes no finding that an election law violation occurred, or when the board determines that a letter of instruction is preferable to a statutory sanction, just so we all know the difference between those two.
Commissioner Brooks, do you have any comments, anything you want to say? She might have to run.
No, not at this time.
Thank you. Does anybody have any more comments before we get into recommendations on decisions by the board? Does anybody do we have a motion on whether to, do we have a motion on what the board wants to do?
I'd like to make a motion that we downgrade this letter of caution to a letter of instruction and have some better guidance on electioneering and things provided to these election officials. They've done a fantastic job, and that's why we're #1 in election integrity in this nation. That's my motion.
Got a motion to downgrade to a letter of instruction, and then you said change up how we do our training. Okay. Generally speaking. Okay. Do we have any discussion on the motion? Do we have a second?
I second the motion.
We got a second.
Mr. Chairman, Commissioner Clemmer, just as a point of procedure under the Administrative Procedures Act, you've got to have some sort of decision on the findings of fact and conclusions of law in terms of not just the disciplinary or what you're ordering be done. And I'm not certain how you want to approach that. I don't know whether or not the commission believes that the findings of fact, well, certainly the stipulated facts, if you believe that's sufficient in moving forward, that would be, I think, more than adequate. Maybe, Mr. Kendricks, what's your, we want to chime in on this one way or the other, Mr. Gibson? I think belt and suspenders, we need to have some sort of decision on the allegations that have been pled.
I think your suggestion makes sense.
Yeah.
I agree. I concur.
Yeah. Commissioner Clemmer, would you be amenable to including the stipulated facts, or really any facts that you would like that you think have been proven by a preponderance of the evidence in your motion and amended?
May I help?
Yeah.
I would again go, poll worker was improperly turned away versus what was stipulated that he voluntarily left. Would that meet your requirement?
So the motion would be in agreement with the stipulated facts and downgrading of,
To a letter of instruction.
to a letter of instruction. And that's not worded very well. I'm not sure how to get pretty fast.
Do we have a second to the amendment?
Second amendment.
Thank you. All in favor of approving the amended motion, say aye.
Aye.
All opposed?
Nay.
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 4 yeses, 2 nays,
3 nays.
3 nays.
3 nays, 3 yeses. Unless-
So 3 to 3.
Chair.
Chairman, I guess you have to,
Yes, sir.
you have to vote to break the tie one way or the other.
I vote to, letter of caution.
Well, okay, so,
So I
So
vote,
that
I
motion
actually,
fails.
I actually said nay. I oppose the motion.
so the motion failed. Is there going to be a second motion?
I move that we maintain the letter of caution on the issue as to whether a button with a likeness of President Joe Biden displaying the words "weak men create hard times" constitutes electioneering under ACA Section 7-1-103, Section A, 8C, little I. And on issue 2, whether it's proper or improper for a poll worker to prevent an individual wearing such a button from voting, based on the stipulations of the parties, with the addition, with the change in the stipulations at one place indicating that Mr. Ballard was turned away from voting. And that we have the additional training that was recommended by our staff and approved by this board previously, with the addition of SBEC forms being available in all election and county clerk offices for use when filing complaints.
A second.
Second.
Second on the motion. All in favor of motion, say aye.
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 All opposed?
Nay.
No.
I vote in favor of the motion.
Motion passed, 4 votes to 3. I will ask staff to reduce that decision to writing. Please make certain that the respondent, as well as respondent's counsel, gets a copy of it along with a cover letter or information sheet that notifies them of their appeal rights. If there are no further questions or comments, I will call this hearing closed. Thank you all very much.
Thank you.
Thank you.
Thank you.
You bet, take care.
Commissioners, we're going to take a 5-minute break. All right, we are back in order here. We have completed the public hearing regarding case 24-45. Next on the agenda is consideration for staff recommendation in SBEC case numbers 24.
Mr. Chair, before we move to that, can I ask that an item be added to the end of the agenda? It's regarding resolution number 2 of 2025. That'll be calling for a hearing in a case where an offer of settlement has been rejected.
Yes, we.
I'd be happy to move that we add that.
All right. All in favor of adding that item to the agenda, say aye.
Aye.
All right, that'll be item number 9.
All right, thank you. So now we're going to consider case number 24-83, Director Madison and Mr. Kendricks.
Mr. Kendricks?
Board, Commissioners, in SBEC 2024-083, There are 10 issues that were investigated. One was against a poll supervisor, one issue was against a poll worker, and the remaining 8 issues were against the CBEC. The first issue was a question of whether or not the CBEC had failed to announce a time to count the absentee ballots. Staff during the investigation obtained a notice of election, which plainly stated when the absentee ballots were to be counted, and staff did not find evidence that the CBEC did not comply with the notice of election. Thus, staff is recommending that this portion of the complaint be dismissed.
I move we dismiss this portion of the complaint.
Second.
All in favor of dismissing this portion of the complaint, say aye.
Aye.
It's dismissed.
The second issue is whether the CBEC provided all the required postings for the polls. As in other counties, this issue mirrors what's happening in many other counties across the state. And as what happened there and seen most recently in SBEC 2024-082, staff is recommending that this portion of the complaint be resolved with a letter of instruction to the CBEC.
Is there any discussion from the commissioners on the recommendation of a letter of instruction, the second issue?
I'd make a motion to accept the letter of instruction.
A second?
All right. All in favor of approving the letter of instruction, say aye.
Aye.
Any opposed? Okay. Thank you.
The third issue is a poll supervisor was heard stating that they talked people out of voting provisional ballots. At the central count location, the state monitor heard a poll supervisor stating that they did not have any provisional ballots or provisional votes as they talked voters out of it and allegedly said as they would not be counted anyways. Staff were not able to speak with the poll supervisor as they had scheduled an interview with staff but canceled and informed staff not to contact her unless it was through the counsel they would be obtaining. Thus, staff are recommending the state board consider issuing an offer of settlement, including a statutory sanction against the poll supervisor.
And commission, if I might, on this one, it's one of those things where the poll supervisor may have been saying this type of thing in jest. We were not able to identify evidence that they actually were doing this, but a sanction letter would say, you don't say things like this, and oh, by the way, if you are doing this, it's a crime, and we're going to investigate it further. So at this point, we just didn't have enough evidence to tip the scales over to the interfering with voting, and that's why we were suggesting a sanction.
Because of her lack of cooperation?
That's part of it, and just, I mean, if we'd had opportunity to speak with her and get her side of it, I would have appreciated that, but the fact that it was just said there at the end, I'm giving it the best light, is that it was, you know, in jest, they didn't have any provisional ballots, but I think a sanction letter is appropriate because the poll supervisor shouldn't be saying that in the central count.
Well, she said it significantly enough that the monitor put it in their report.
Well, the monitor was there and overheard it.
Right. And I would hope our monitors would know if somebody was saying that in jest, they would know the difference.
And that's why we're suggesting a sanction, but not necessarily a referral for criminal investigation, because I don't think there's enough evidence here or available for criminal investigation. If I had a voter who had been saying that, I would probably tip the scales more towards recommending criminal investigation. But on this one, I think it falls within our authority, and that's why we suggested what we did.
So I just want to be clear on what we're looking at here. If we send a letter to her, we would be saying it was brought to our attention through the monitor report and provide a copy of the monitor report and say that this is a violation of election law and cite the code section and then add a letter of caution. Would it be phrases that because we are saying that from the information we have, there is a violation of election law.
Correct.
So, and then she could appeal it and explain.
And request a hearing and come present to the board.
Okay.
Her side of it.
So then I will move that we do that we send her a letter of caution indicating the statutory violation based on the monitor's report, provide the monitor's report, and indicate, I also think we need to indicate it, and she did not cooperate with us.
May I ask a question?
Yes.
Before we complete the motion? At this point, if this person has not investigated, alleged they don't get counted anyway, and talk people out of it, is a letter of caution enough?
I mean, the reason I said a letter of caution was because we don't have more information.
Okay.
That's the only reason I said that. Like I
Did we
said.
give you some more information?
No.
No, you can't talk while we're having our meeting.
We've seen this thing in times past. I don't know why we're not decertifying this person.
That's where I'm leaning.
And I'd like, I know you made a motion, I'd make a counter motion that we decertify this.
A friendly amendment?
A friendly amendment.
But I would just, and reason, one, we're not making recommendations anymore, and I appreciate that. But really, the evidence on this was pretty thin, other than just a statement. And that might, because decertification in a lot of ways is the one of the biggest
Right.
things we can do. And
But she did not cooperate, she did not respond.
in her, now.
She was out of town. She was out of town.
Yeah,
You're
man.
gonna have to leave. You're gonna have to leave right now. Leave right now, because you cannot keep interrupting our meeting. Do you understand that?
I only did it once. She wasn't
Okay.
what she
So
said.
make her leave.
Ma'am, you're not going to, there's no public comment at these hearings. I
I will be
appreciate it.
quiet from
All
now
right,
on.
thank you.
So a respondent is not legally obligated to respond to our questions.
Okay.
So while we have that they didn't want to talk to us in here, because they could have come in and just said, whatever, I was joking, or they could have said I meant to do it, or whatever. I'm not counting that as part of the factors in this, because what I'm looking at is what facts were we able to develop in the investigation, and then their behavior afterwards is not a factor I'm considering at this point. Does that make sense? And so I'm just looking at what evidence did we have, and that's why I'm thinking a statutory sanction letter is appropriate, and that's why I'm asking for that. Is it
appropriate to attempt to contact again if they had originally scheduled and did not, or should we move forward?
So at this point, it's a move forward point. And really, here's the way it works. If, let's say we do the offer of letter of caution, or a letter of warning, or a letter of reprimand that the board decides. They have the opportunity to reject that offer and then request a hearing and then come present to the board specifically their response to this. And so at this point, we're saying the evidence we have says this was said based on our monitor report. I don't have any countervailing evidence. I don't have any evidence that it was actually done in the poll. Does that make sense? And so what this is looking at is you're saying this as a poll supervisor is inappropriate behavior as a poll supervisor. That's fully within our sanctioning authority to be joking about this type of behavior. And a sanction to that fact. And then the sanction letter would also include the code section that says, if you are doing this, recognize you're committing a crime that is punishable by jail. And so the sanction would include that reference to, hey, you're interfering with voters' rights to vote, and it is a crime to do so. And so that's kind of how we were structuring this approach.
So, I wanted to dig a little bit deeper. Who witnessed this statement?
The poll monitor at the central county.
At the Central County?
Yes.
That seems pretty clear cut to me.
We present the evidence. I'm just telling you the evidence we have. And if I put my law enforcement hat on, there's not enough here to go after criminal-wise. And that's why we're saying sanction. And if I'm looking at just the behavior of saying this at the central count, and it may have been that they did not have any provisional votes, like anybody needed to vote a provisional ballot. That's entirely possible. And so she was in jest saying, I'll talk them out of it, but I would count it anyway. May have been actually doing it. I don't know. And at this point, the evidence we do have is that this was said, and saying this at the central count is within our jurisdiction.
So, if I may, a letter of caution does what in this instance? It acknowledges that the allegation was the law was broken, but there are no sanctions, nothing to mitigate future occurrences.
The letter of caution is the public sanction,
Yep.
and that is the thing. And so then this poll worker is on notice that this behavior is inappropriate. I would anticipate future election cycles, monitors being present, and this gives clear notice that their behavior is inappropriate. And if they're engaged in this behavior in the future, hey, we're coming. And it's just to give clear notice that this is inappropriate behavior. Does that make sense?
It does, however, with the allegation of talking people out of it and that they do not get counted anyway. I question whether or not that is enough, given the facts that we have.
Well, and again, that's why we raise it to the board. Just the facts that I'm looking at, when we're looking at it and discussing it, is we know this occurred at the central count. I don't know what was happening in the poll, and I don't have evidence that it was actually occurring in the poll. Does that make sense?
It does, but whether or not it happened at the count or in the poll, it shouldn't have happened. And if it did happen, then clarity is needed in my estimation.
I don't remember this from the monitor's report, but did the monitor's report just have this statement, or was there some context in the monitor's report about the circumstances of the statement?
It was, and there were a lot of monitor reports, but it was in one of the types of text sections that the monitor included a comment about this.
Just a comment, but not any
Context.
not any
No quotation.
No quotation,
no explanation of the situation. Or
No, just other than at the central count, when they were turning provisional ballots, the poll supervisor was overheard saying this.
I'm reluctant to use our strongest punishment on something we don't really know a whole lot about. But that's my feeling.
Well, that's why I recommended
Yeah, I'm-
the letter of caution.
When I'm trying to get my phone.
Director Madison?
Yes, sir.
Is there a way to investigate that if someone had come in and presented themselves to vote and then they did not vote, identifying those individuals and questioning them about why they did not?
We tried and were unable to locate any such voters. And that's part of it, is I wasn't able to develop any of this evidence to substantiate that this was actually occurring in the poll. And that's why I'm looking at what was said in the central count is in and of itself a thing, hey, you shouldn't be saying that. And if you are thinking of doing this type of behavior, saying this in the poll, it's a crime. And that's where I'm getting at.
I agree with the letter of caution.
So is that a second to the motion for letter of caution, sir?
So a few years ago, I built this kitchen out.
Do all in favor of the letter of caution on this third issue in the case, say aye.
Aye.
Any opposed?
Nay.
The letter of caution passes. Issue 4.
Okay, the fourth issue here is that a poll was staffed with only 3 poll workers. Staff found through testimony from one of the poll workers who worked that day, on election day, that the polling location was indeed staffed with only 3 poll workers. Thus, staff are recommending that the state board consider issuing an offer of letter of settlement, including a statutory sanction against the CBEC.
And as the board is aware, staffing is always an issue. This occurs, but there's a legal requirement to have 4 poll workers at a poll, and the evidence adduced in this poll was that there were only 3 poll workers.
Question, does this county have poll centers?
Voting centers?
Voting centers, I mean.
I think their election day is precinct. I think they're precinct based voting. It's a small county. So.
I understand.
Yeah. And we've dealt with this issue before with other counties, so it's one of those things that's an ongoing challenge.
How's it previously been handled?
In the offer with caution, warning, those type of things. Because staffing is always a challenge, and it's always a challenge to get enough poll workers lined up, and you may have poll workers lined up and then someone can call in sick or whatever. The fallback is the CBC should come out there and staff it until they get some other people there. We instruct them to make sure they have extras available so they can do that. But sometimes things just happen, and this happens in other counties.
Well, then I would move we send a letter of caution regarding the polling site staffing, including the statutory violation in it.
Second.
All right. All in favor of a letter of caution as to issue 4 in this case, say aye.
Aye.
All right. Mr. Kendricks, issue 5, please.
The fifth issue was whether or not all the polling locations met the ADA specifications, specifically in reference to the electronic marking devices. Staff found through documents gathered from the county clerk and additional files provided by the monitor that multiple locations did have the required electronic voting machines up and running. Additionally, staff obtained receipts that showed that ES&S did appropriately program the electronic voting machines for this county. Thus, staff recommends this portion of the complaint be dismissed.
I move this portion of the complaint be dismissed.
Second. All in favor of dismissing issue 5, say aye.
Aye.
All right. Issue 6, please.
Excuse me, before we start, can we check and see if Ms. Brooks is still on the phone? I think we may have lost her after the break.
Commissioner Brooks, are you on the line with us?
That's what I thought. I thought we lost her after the break.
Go ahead, Mr. Kendricks.
All right. The sixth issue is that a poll worker was heard speaking in support of an initiative on the ballot to several voters. The monitor reported that as they entered a poll at 9:57 a.m., they heard a poll worker speaking with voters about how they wanted ballot issue number 2 to pass, as they knew someone who wanted to work at the casino. The poll worker continued to speak on the matter until the monitor shushed them by putting their finger up to their lips. Staff attempted to contact the poll worker multiple times, but were unable to reach the poll worker. Thus, staff is recommending the board consider issuing an offer of settlement against the poll worker.
For electioneering?
Yes, ma'am.
Our election monitors submit their reports under oath, under penalty of perjury.
Correct, and they're trained by us, and I mean.
I have been one.
Yeah, I know. I'm speaking for the audience purposes.
You know, I think either decertification would be appropriate in this.
Yes.
I'll second that.
So we have a motion to decertify on issue 6, and we have a second from,
What duration?
I'm sorry, yeah.
How many elections?
And under our rule, we do it by federal election cycles, which are 2-year terms, and the minimum we can do it is 2-year terms, which would be 4 years.
I'd recommend two-year terms.
Okay.
Second. So all in favor of decertification for 2 federal election cycles, 4 years, say aye.
Aye.
Passes. Issue 7, please, sir.
The seventh issue was a tech person was seen touching ballots during the hand count process. Staff found that the individual in question had placed their hand on a stack of ballots. Upon noticing this, then the monitor notified 2 members of the CBEC who stated that he should not have been doing this. The members went and spoke to with the tech person. Further, SBEC staff member who was present for the entire duration of the hand count stated that he did not notice the individual touching or handling ballots for the remainder of the night. Thus, the staff recommends resolving this portion of the complaint with a letter of instruction to the CBEC to further ensure that non-election officials do not even accidentally touch ballots.
And the testimony was like he was laying on the table and set his hands like this on the stack of stuff. That's what the testimony.
Okay. Then I think a letter of instruction to the board would be appropriate, just to be careful in the future.
And they addressed it, and it didn't happen anymore that we observed.
Okay.
I'd second that.
All right. All in favor of the letter of instruction as to issue 7, say aye.
Aye.
Passes. Issue 8, please.
The eighth issue is a question of whether or not the video and ballot imaging equipment as seen in the photos provided to you used during the hand count process was appropriately purchased. Staff found that the county has specific procedures for processing payments and contracts. Staff were unable to obtain a receipt or contract for the equipment as seen in the pictures before you used during the hand count process. Staff did find an invoice that did specifically pay for the same equipment and services that were used during the primary. And on Monday, June 9th, following your receipt of the report on June 6th, staff received an invoice for the November election in the amount of $100 from the CBEC. Proof of payment was not included with the invoice. These facts support that payment has not been made for the equipment and services, and that the usage of this equipment and services went to further the CBEC's duty to have a public hand count, where the public can ensure that the count was fair and accurate per Arkansas law. Thus, staff are recommending state board consider issuing an offer of settlement against the CBEC for receiving a gift that went to further the CBEC's duty.
So they received an invoice of $100 for which equipment?
All of that equipment that is in those pictures, so I think it's like 10 TV monitors, GoPro cameras, scanners, and the tech people to run all of that equipment as well.
Sounds like a good deal.
Yeah, way too good.
So we don't really know where this equipment came from. Or he get-
We have an invoice now that states it came from a third party.
Third party.
And
Were they specified?
So the invoice that we received on Monday was from AVII for the providing of this equipment, if I remember correctly. Is that correct?
yes, it was from AVII.
And so the issue is that you have the video equipment, and as we discussed in the primary, the recording of the things and posting, we addressed that issue in the primary, saying that that's not really a bad thing for people to audit and check the thing. The board has a legal responsibility to make the hand count publicly available so that they can ensure that it's fair and accurately done, and there's rules that govern that. And the board took the additional step to provide this video equipment, which I think the use of the video equipment is good, right? Like it makes it where you can see what's going on at each table. And if you'll notice in the photographs, the one where it's just the tables like this, the taped area is marked because that's directly under the camera, and the poll workers were putting the ballots there for purposes of going through line by line for counting. And then that was live streamed or broadcast on the TVs for the public that were available, and they could observe what was going on with this specific table. So each TV represented a table. So I think this furthered the mission of showing the fair and accurate count of it, but then we get to the issue of whether or not this is donated equipment or not, because we have a prohibition on donated
Right.
stuff for election.
Isn't AVI
That's Conduit
they're the ones
Reynolds.
that also want paper ballots in Searcy County, fine, well, but aren't they, isn't this electioneering, should this not be referred
So-
to the AG?
So I don't know if this is, it would not fall under electioneering, is my understanding of electioneering. And what it really falls under is
Ethics.
whether or not this is donated election, and we have provisions that specifically prohibit county officials from using donated stuff. That has to come from either the state, city, if the city's run election, the county, the state, or the feds.
Especially by somebody that has a vested interest in a certain outcome of certain elections.
And I will tell you, in purposes of our analysis and discussion, we didn't examine that at all. The only thing we looked at is, does this further the mission of the CBEC to provide transparency, which we believe it does. It's a good use of equipment. There's no doubt the county could purchase this equipment and have a county official run this equipment. So if you're using a third party, whoever it is,
Right,
to do
doesn't
this,
matter who it is.
then the question is, well, it should be properly documented and not be a gift, potentially. And that's what these remaining issues kind of get into, is this right here.
Properly documented, this is more than $100 worth of equipment by any retailer, any company available. So at that point,
The very fact that they're trying to say it was only worth $100 seems like there's an ethics question here. It's a big ethics question for me.
And those that are in our jurisdiction are the CBEC. And so the question is did the CBEC properly document and have a contract in place? And we got, and he discussed it, that payroll records, all election expenses are paid by the clerk's office, paid to the clerk's office. And there were none of these records at the clerk's office. And so that's one of the other issues with this, was the internal tracking of these records was not available at the clerk's office.
but as of Monday, you were given an invoice for $100.
Correct, in response to the subpoena that we sent about 3.5 weeks ago.
What was the invoice dated for?
I don't recall that offhand. I think
Pretty
it's
sure it was November.
It was November
or-
something.
It was like
It was for the
November
November
8th, I
election.
think.
Yeah. I mean, we reviewed it, but we had already submitted the report at that point. We just wanted to mention here that we did get that there was an invoice for it, and the invoice matches the invoice that was used in the primary. We did not explore that in the primary because we were looking at other issues really from the primary. And so this is the issue that's squarely before us now. And the question that the board has to decide is, does this further the CBEC's purposes? And if so, what are the appropriate requirements of a CBEC anywhere in the state that's wanting to do this? And like I said, the use of the video equipment from a transparency standpoint, I think it's a great idea. But I think there's a question about whether it's properly documented and properly compensated for.
Would every CBEC get the same rate deal on all of this equipment, should they choose to pursue the same thing?
I said that again, I'm sorry.
Would they get the same great deal for every county in the state if every county wanted to do it?
That's a question for you.
And every county would be in violation because
I agree.
it's a gift.
Yeah, that's functionally it. So,
Mr. Williams, I want to fall back on a comment he made earlier, take it a little farther. Is it under our purview to refer this to the Ethics Commission?
I don't know if it falls under Ethics Commission. I know the donation portion for an election official is squarely within us. And so the sanctioning authority or the investigative authority for the election official receiving a donation or gift. And if you'll recall, the donations came from the 2020 election when social media folks were dumping millions of dollars across the country to promote mail voting. And then we adopted a law in the 21 session that prohibits the receipt of gifts or services or equipment outside of being funded by the government officials. And so this falls squarely, in our estimation, and that's why I presented to the board, within that prohibition, which I believe is fully within our jurisdiction to address. I don't believe that this behavior falls under any criminal statutes. So we're not looking at referral for like law enforcement purposes, but I think this is a question that we need to establish a clear rule on for other counties to know that, hey, if you want to do this stuff, great, but you've got to address it and document it properly.
So if I came to you and I said, I'm going to give you this Cessna 192 plane, if you do certain things for me, what is that called?
So if there's a quid pro quo and you're doing that to try and get my government services, there may be ethics violations for that.
And you don't see that as even close to being this?
I have not considered it in that way, and I don't necessarily get it. And that, I mean, part of having this discussion is for you as the board to address those issues.
Like I had some pictures here of ABI's van parked, ABI's vans parked outside the polling place. Did I not see pictures of some of that?
So, but if, in the scenario of you getting an airplane, they wouldn't even ask if there was a quid pro quo.
Yeah.
You would just get popped.
I would just get popped. Yeah. So, and I think what may be important is to consider this issue. Yeah, I mean, this issue really addresses that, and then the next two issues relate to the workers that were doing the handing out. So this really encapsulates the question of whether or not this is a one that I think the board has to answer: is this in furtherance of the CBC's responsibility for transparency? And if you answer that as yes, which I believe it is. In fact, there's previous testimony from the chair that this is in furtherance of the transparency. And then if you answer that yes, and the second question is the absence of a contract, absence of receipts for this, evidence that this is a gift?
But I struggle, so I think I understand the advocacy of it is for transparency, but transparency acquired through less than transparent means is what I take issue with. So it may be the appearance of transparency, and functionally it may be, but I don't understand $100 for this equipment, and the fact that it came late after initial investigations were initiated. It doesn't seem right. So from that standpoint, great, we have this so that we can showcase it, but if it was acquired through ill-gotten means, I don't think it's transparency. I think it's
a gift or it's fraud.
Yeah.
And that's, I mean, the authority we have on this is related to the donation aspect of it, and that's why we raised the issue here. And the reason I say I believe it is transparent is because if you're in the public area observing this, you can see what's going on at each table, and that provides that service. And there's no doubt in my mind that a county could buy all this equipment or have this equipment and set it up and run it as part of their transparency.
Yep.
Right, but they would have to have the money to pay for it.
They'd have the money to pay for it, yeah. And you could also hire a vendor to do this, which is, I mean, you could do a vendor, but then the question is what's the fair value? And, you know, we raised the issue to you as whether the $100 is reflective of fair value.
No.
So that's
The board, we just need to decide on what statutory sanction we want to issue to, in this case, this issue, the CBEC regarding the donation issue.
Correct, and for the offer of settlement, they would have the opportunity to reject it, and then, again, come here and present their side of the story to the board.
I struggle with this just from a professional background. I know the equipment at hand is worth much more. And so in my mind, the main issue at hand, if it was acquired legally, I do not believe that it was. And if donations are prohibited, I would make a motion that we decertify.
Motion to decertify all members of the county board?
Yes.
And that is your motion?
It is.
And for how long, what term? The minimum is
Yep,
two?
it goes 2 to 14 years based on up to 7 election cycles.
Yes.
It's
4 years.
Minimum is 4 years, maximum is 14 years.
Yep.
Yes.
I'd move 14.
Okay, so the motion is decertification of all of the county board of election commissioners for the max term of 14 years. Is there any discussion on the motion?
A second.
All right, we have a second. All in favor of the motion, say aye.
Aye.
Commissioner Brooks, are you with us? Or any opposed, say nay.
No, Smith.
All right, it passes. On to issue number 9.
Issue number 9 is whether the public was properly notified of the election officials who worked the hand count process. Staff found that the list of election officials who performed and conducted the hand count process was not posted in a manner that would give the public notice of the hand counting officials. Staff received a typed list on Monday, June 9th, which was after the report that had been submitted on June 6th. The monitor and staff member who were present in Searcy County on election day had neither observed nor noted this list. The monitor and staff member observed a handwritten list of counting officials. Staff compared this handwritten list of election officials posted to the list of election officials that were posted in the courthouse and found that the names on the hand count list, the handwritten hand count list, were not the same as the list that was provided at the courthouse. And upon further review, the typed list and the handwritten list do not match either. Thus, staff are recommending the state board consider issuing an offer of settlement against the CBEC for failure to properly notify the public of all election officials for election day.
Any discussion on issue 9? Any recommendations from the commissioners?
I would say a letter of reprimand would be appropriate because that requires them to refrain from engaging in the same activity again. And it's condemning the fact that they didn't. It's really bad when you don't provide appropriate information to the public. And so I think this is really not a good look for this county to not be putting up who's there and this is who's counting the ballots. And they haven't put that up correctly.
Second.
So the motion is to offer a letter of reprimand.
Correct.
Correct. And we've got a second. All in favor of the letter of reprimand, say aye.
Aye.
Any opposed? All right, issue 10, please.
The final issue is that several election officials who worked the hand count were either not paid appropriately or were not properly documented as volunteers. Staff found that some of the election officials on the aforementioned handwritten list were not included on the payroll documents maintained by the county clerk. Additionally, the county clerk's office did not have any affidavits for any election officials waiving the statutorily mandated pay. Staff did obtain signed affidavits on June 9th from the CBEC, but they were not maintained with the payroll records as is instructed on the instruction sheet of the affidavit. And additionally, There were people who filled out the form that we received on the 9th that did get paid for the general election. And consequently, the evidence shows that the CBC did not appropriately maintain its required waivers for all the election officials who wish to waive pay. Thus, staff are recommending the state board consider issuing an offer of settlement against the CBC.
And so really what this is the clerk had none of these records. We received some waivers in the packet Monday, and it may have been that they were paid for a portion of the election and then waived doing the count, but because those records weren't maintained with the payroll records, which is one of the things we have in the instructions in the affidavit waiver, and to protect the county from the Department of Labor investigations,
Right.
because you have to pay people or have the waivers on file, the fact that it wasn't there. Either way, this paperwork was not done properly, and it puts the county at exposure through like Department of Labor investigations for not paying their poll workers minimum wage, which are legally required to do, or having the signed waiver, which our law allows to do. That's all I have.
Any discussion, any motions from commissioners?
Well, I think they should get a letter of reprimand for this, too. Especially because it puts them at risk for investigations by the Department of Labor. And that would be a lot for the county to deal with if that happened.
I'd second
Is there a training, I apologize. This is addressing training, isn't it?
We cover that they can execute a waiver to avoid paying poll workers, and then the instructions themselves on the waiver that we provide says this needs to be maintained in your payroll records. And again, if you have any questions about it, contact us. And it's to protect the county
Right.
so that they aren't getting.
May I make an addition to your motion?
Yes,
Could we do training on this as well?
yes.
Yeah, we can expand this in our training, absolutely.
Thank you.
So a letter of reprimand and
Direct.
direction to attend additional training to be specified by the SBDC staff.
Second.
Hey, Commissioner Williams, did you, as part of your motion, or your amended motion, that you wanted to be going forward, included training for everybody, correct?
Yes, please.
I'll accept that as second.
I don't
Yes,
put
yes,
words
sir.
in
No,
your mouth.
it is. That is what I meant, sir.
Okay,
I apologize.
Okay.
So to make sure I understand, offer of letter of reprimand, training related to the paperwork, and then direct staff to include additional information on this in our future trainings as we go
Yes.
forward. Is that correct?
Does that reflect?
It does. Thank you.
Commissioner Williams, that's your motion. Do we have a second to that amended motion?
Second.
All right, thank you. All in favor, say aye.
Aye.
All right. Passes. All right, so now we are done with that case. Moving on to SBEC case number 24-086, Director Madison.
Okay. And I know you can go. This one has 15 issues. It's from a monitor report, but we really only have 2 suggested real findings. I'm gonna go through this relatively rapidly. Issue 1A is that the courthouse was missing some of the voting posters. It was raised to the clerk's office. They immediately fixed it. This was the first day of early voting. We recommend dismissal on that one.
I move we dismiss this one.
Second.
All in favor of dismissal, issue 1, say aye.
Aye.
On issue 1B, the monitor noted that some election officials had not taken their oath of office as of 8 a.m. Voting begins at 8 a.m. in early voting. Again, this was an oversight and them getting started. They corrected it and it was addressed. And we would suggest a letter of instruction to the county clerk as the one overseeing early vote, ensuring that all officials are appropriately given the oath prior to service as an election official.
I move we adopt a letter of instruction be sent to the county clerk regarding the necessity of oversight and ensuring compliance with legal requirements.
Second.
All in favor of the letter of instruction, say aye.
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 Item I C, or the third issue, the monitor reported that a voter presented with a Texas identification and was not allowed to vote, wasn't offered a provisional ballot. Come to find out, one of the commissioners was actually dealing with this person and testified to it pretty specifically. Apparently, the Texas resident was visiting Arkansas. This is the first day of early voting, and wanted to stop in and vote. And said they were a resident of Texas, not a resident of Arkansas, were not registered in Arkansas, didn't want to be registered in Arkansas. And so the commissioner said, well, you can't vote here. You need to go back to Texas to vote. And while I understand the commissioner's position, the law still requires a non-registered voter to have the opportunity to vote a provisional ballot. So I would suggest that we do a letter of instruction to CVEC and just say, hey, make sure you at least offer a provisional ballot. If the person wants to do it, cool. If not, and the guy left, he took his ID and left, but he said he was just visiting and wanted to stop in to vote. And
that's
we had in the 2020 election, we had a call from a lady who had her Georgia absentee ballot and wanted to know if she could drop it off at one of the polling locations here in Arkansas. And we told her no. So it's along the same lines.
Of the training, you specifically addressed it in training that you would let them vote provisionally and then research it and determine whether or not that ballot was legally eligible, and then the person would be contacted?
So the way the provisional balloting works is I show up, if I'm not on the voter registration list, they're to contact the county clerk. And if the county clerk can't find them, then I get to say, well, I want to vote, and I'm going to vote a provisional ballot. The key is that the poll workers have a legal responsibility to offer the provisional ballot as the fail-safe. We covered that in training. They didn't really do that. I understand why the commissioner didn't, but this is one of those things is like, you still got to say, would you like to vote a provisional ballot? And that's what I would say.
On that ballot, does it not say that if you say you're legally here to vote, you have committed a felony if you're not?
That's correct, it does. And so that gives them the opportunity for the voter.
To make the decision.
Right, but here, because of the way this was done, the commissioner kind of prevented it from happening, and so that's why the letter of instruction.
But in the letter of instruction, state about the penalty.
Yeah,
and point that out to the voter who's doing this before they
fill it out.
Yeah.
Because once they offer it.
Yes, that's a motion.
Second.
All in favor of the letter of instruction, say aye.
Aye.
Okay, now we're moving to election day. At the United Methodist Church, the poll supervisor failed to print zero tapes from the tabulator. There was a little bit of conflicting testimony other than everybody agreed there were no zero tapes produced at this location. The conflict was whether or not the poll supervisor canceled it or whether the poll supervisor, as he testified, just forgot to print it. And I'll give the poll supervisor credit. He was very forthcoming in my interview with him. He recognized this is an issue. It was his first time working as poll supervisor, but you got to have zero tapes. And so we're recommending y'all offer to settle with a sanction to the poll supervisor.
And it was the first time he would have been the poll supervisor?
Yes, I believe that's correct, yes, if I remember the testimony. I interviewed like 12 people on this case, so I believe that's correct, yes.
Okay, then I would move we send a letter of caution.
Second.
All in favor of the letter of caution, say aye.
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 Item 2B, which is issue 5, sample ballots were alleged to not have been in the poll. They were in the poll. They were just on the supervisor's table behind him in the packet. We're suggesting a letter of instruction to the poll supervisor to ensure, and to the CVEC to ensure that, hey, when you send the sample ballots and the notice of election, they're in something separate so that the poll workers remember to put it out. Also, we're going to include in our training, Commissioner Williams, on our poster boards, which worked really well. A notice that's written on the poster board is, have you posted your sample ballots? Have you posted your notice of election? To remind the poll workers of the poll. And so this is an issue we've had all across the state, and so we recommend a letter of instruction.
Motion to send a letter of instruction to the poll supervisor.
Second.
All in favor of the letter of instruction, say aye.
Aye.
Now, this is another one that's challenged. Oath of officials was not executed as of 2 p.m. It's the poll super's responsibility. And what it was is some had taken the oath, but some had not. And when the monitor asked to see it, they didn't have the forms filled out. And this is also the supervisor that didn't print the zero tape. I think he was having a chaotic morning. to say the least. And the monitor shows up and says, hey, where's these at? Because monitors were looking for these things. And so I would recommend a statutory sanction because oath of officials is important. That way they're under oath doing their job. And they all testified that they did it. They just couldn't remember if it was prior or later in the day.
I move that we send a letter of caution.
Second.
All in favor of letter of caution as to the oath of officials, say aye.
Aye.
There was an allegation regarding, this is issue 7 of the case, regarding spoiled ballot handling. We were unable to find any evidence that they handled spoiled ballots incorrectly.
I move we dismiss.
Second.
All in favor of dismissal on this issue, say aye.
Aye.
All right, issue 3A, or the 8th issue of the case, poll was missing notice of election and sample ballots. Again, they were provided by the county, just not posted out in the very front. They were in the packet of stuff. And again, this is a training issue, so we recommend letter of instruction to the poll supervisor and to the CDC.
I move we send a letter of instruction.
Second.
All in favor of the letter of instruction, say aye.
Aye.
This one, the poll was alleged to not have been open until 7:40 in the morning. Everyone, the supervisors I spoke to testified that they were at the poll at 6:30 to 6:45, began opening the poll. This particular poll had some experience, if I remember correctly, with the poll tablet. The county had contracted with ES&S to have a tech person on hand. They dispatched the tech person from the county courthouse to this location. It's about a 25-minute drive. Got there, they got the poll. They were issuing ballots manually in the interim, and they got all the equipment up and running by 7:40. So that's why we're recommending dismissal of this. I mean, they handled it as best they could.
Move for dismissal.
Second.
All in favor of dismissal, say aye.
Aye.
Great.
Okay, so this one was really interesting. The monitor reported that the poll supervisor was, quote, spoiling ballots to make the reconciliation count balance. And everybody I talked to was like, what are they talking about? Until I got a hold of the poll supervisor. And what it was throughout the day, she reviews the poll tablet ballots issued against the list of voters, against the public count on the DS200. Those weren't matching up.
Oh, so she just spoiled ballots?
No. She recalled she had spoiled ballots and did not include that in the count. So she was referencing the fact that I need to count the spoiled ballots as part of the ballot count of issues, and that reconciled it out. And
I'm glad you said it that way because I read it the exact opposite.
Yeah.
I want to make the numbers work.
Yeah, exactly.
And the way that came from the monitor, that's what I thought it was. And so, I mean, like this was one I was really digging into, and I interviewed the poll supervisor, and that was what it was. And I've done some other investigation on it, and the poll tablet shows the number of ballots it's issued. And so let's say we have 50 voters, but it's issued 52 ballots. Well, if I've spoiled 2, I got to account for those to make everything reconcile.
And all the totals when you investigate and match.
Yeah, they were fine.
I move we dismiss.
Second.
All in favor of dismissal, say aye.
Aye.
Okay, issue 11. This location, it was interesting. It is a newer facility, but it is a city building, but it doesn't have any marked handicap parking spaces. When I spoke to the commission, they all said, this is a new building. Surely it has marked handicap spaces. It does not. I've sent them back out there, and they sent photos of this location, and it does not have marked handicap spaces. They have orange cones that they set out, which apparently denote that this is now a handicap spot, but I'm not sure of that nomenclature.
Well, they should be careful because the feds will show up just like they did in Madison. Was it Madison or Carroll County?
Newton County.
Newton, right,
Newton County.
right up there, yeah.
So we're suggesting a letter of instruction to the CBC, and they either put up a temporary handicap spot or work with the city to just mark a handicap spot. They had ramps, and we'll talk about that in a minute. I mean, otherwise it's ADA compliant. They just need to have a marked handicap spot. They can put a sign up. So letter of instruction to the CBC to work with the city to put a handicap sign up.
I move we send a letter of instruction.
Second.
All in favor of the letter of instruction, say aye.
Aye.
All right, so this one, when the monitor reported that a wheelchair's voter front wheel fell off an unguarded ramp to the entrance of the poll, the ADA part of me had a mild heart attack. And then when I got photos of this location, and they're in the report, the ramp is about this tall. It's about 3 inches tall.
Oh, okay.
It connects the front porch to the front door, and what it is the wooden ramp with tread is the width of the door. It needs to be about 2 feet wider, so that when you're exiting or entering, you can get on the ramp and open the door because the door swings out. They tried, they're about 80% there. They just need to work with the city to make a wider ramp for because the door sits up off the threshold a little bit, and they need a ramp that's a little wider. So recommend letter of instruction to CBC to work with the city about expanding the ramp.
May I ask a brief question?
Yeah.
What if the city says no?
Then the commission consider whether to continue using that location as a polling location, or they can bring their own ramp.
Got it. Thank you. Make a motion to accept staff recommendation for a letter of instruction.
Second.
All in favor of the letter of instruction, say aye.
Aye.
All right, issue number 13 is the family church on election day. The monitor reported it did not have handicap parking signs. Sent the commission back out there, and they took photographs around the whole location. This is one of those church complexes that takes up an entire city block. And the handicap parking is on like the northwest corner next to the sanctuary, and voting occurs on the south end of the building in the Christian Life Center. And so handicap parking is here, but not down here. And so it's technically compliant for the facility because there's handicap parking, but we would do a letter of instruction to have the church, they need to just drill the handicap side to the side of the building, and that would be good.
Okay, I move we send a letter of instruction to
Second.
include signage.
All in favor of the letter of instruction, say aye.
Aye.
All right, issue 14, tabulator was not operational until about 7:40. This one was, ES&S had actually been contracted and had set up the devices and failed to include, as I understand it, the activation thumb drive with the stuff that went out with the tabulator. Again, all the poll worker supervisors were there at 6:45 in the morning. They recognized it. They came back to the central location to get the thumb drive, got back. In the interim, they were issuing ballots and marking ballots, and they offered voters the opportunity to put it in the emergency bins, and voters said, "We'll wait." And so they pulled chairs out for them, and they had 4 or 5 voters that chose to wait. The tabulator was up and running by 7:40. Again, I'm not sure what else they could have done other than, I mean, they're relying on ES&S to this, and they just forgot to put the thumb drive in. They got it fixed as promptly as you could ask for, so we recommend dismissal.
Motion to dismiss.
Second.
All in favor of dismissal, say aye.
Aye.
All right, 15th and final issue. This is one we've run into before where they daisy chain the lovely equipment that we have. I'm going to speak badly of ES&S for just a moment. Their marking device has to be 6 feet apart, and their cords are 5.5 feet long. And people daisy chain them together so they kind of drape like this. The poll supervisor testified that this is how they've set it up for several years. This is an issue we've dealt with in other places. And the poll supervisor recognized the necessity to prevent voters from walking behind other voters, and had stationed another poll worker there to escort voters to the machine so they weren't walking behind. But that's not 100% foolproof. So what I'm actually recommending here is a letter of instruction to the CBC. Do 2 things: include extension cords so that they can space the equipment out, tape the cords down.
We're still in the meeting.
And secondly, draw a map out of where to put the devices and the stuff so that the poll supervisor has specific information to follow. That's one of the things we do. And the poll supervisor was very, like, that's a good idea. And so if I'd have known we didn't have extension cords, I'd have brought them. So just instructions, they include extension cords.
That was Commissioner Brooks. She's trying to get in.
Good.
I told her to try again.
Okay.
I don't see her on the list, but then she'll try again and I'll catch her then.
Okay, I just want to give you a heads up that she would be trying.
So this is an issue we've dealt with. The poll supervisor understands the seriousness of it. I would just do a letter of instruction. I would recommend letter of instruction, include extension cords and a map of where to put the equipment. And this is in a like gymnasium that has very limited wall outlets, and so that's the issue.
So they do need extension cords.
As part of this, you mentioned it happens in other locations. I know today we've said a lot, like talking about the training, so that is not lost on me.
Yeah.
Is this something that we should follow up on?
We cover this in training.
Okay.
We cover this in training. What happens is the commission drops the equipment off. The poll supervisors come the day before to set the equipment up, and that's why they need a map.
Okay.
To lay out specifically, put A here, B here.
Got it.
So that you're not relying on the poll supervisor to figure it out.
Motion to accept staff recommendation of a letter of instruction to the CBC.
Second.
All in favor of the letter of instruction, say aye.
Aye.
Thank you for the clarification.
Okay. I believe, now, Director Madison, before we go into the budget, do you want to handle the item we added?
Yes, if we can.
Okay.
So I have a draft resolution in front of you. One of the recent cases with decertification offers was rejected by one of the old supervisors and has requested a hearing. And so this resolution would call for the hearing. I would propose, if you could check your calendars, because we have a busy next few weeks coming up in July. Here's my plan, but I would propose that we do this hearing on July 16th.
I can't.
You can't do the 16th? Okay. Well, the following week, we've got 4 of us going to NASED, and then we have a proposed meeting for July 30th. But
I can do it in the afternoon.
Okay,
On the 16th,
Okay.
not in the morning.
Okay. And the reason I'm looking at that is because we've got to get this case, we've just got to get wrapped up.
Right, and this is something I can't change, or I would.
I understand. 16th fits. July 30th, I don't want to put this on our business meeting for the 30th because we're planning on having at least 2 publications and rules for your consideration on the 30th. And I don't want to put a hearing on that date also. And I would anticipate possibility of additional hearings. And I'm looking at like August 6th for those. So that's why I'm trying to schedule this. This is one, and that's why I'm looking at the 16th. We could probably do it in the afternoon. The issue in this is pretty straightforward. It's from one of our recent cases. And so I'm not going to say it's an hour because I missed that horribly this morning. But it's one of those things that that we got to give the opportunity for. They projected the offer of settlement, requested the hearing. So that would be my proposal, but I'm open to your suggestions.
I can be here by 1.
Okay.
I will follow up, but I believe I can do that as well.
Okay. Commissioner
I can make the 16th.
16th.
30th I can.
Okay. Commissioner Smith?
I think it's okay.
Okay. Commissioner Brooks, have you gotten back in?
I don't have her as of yet.
Okay. Well, let's go ahead, if that's okay, I'll go ahead and put it in, and what I'd ask for is adoption of the resolution with section 1 on page 3 to reflect July 16, 2025, beginning at 1 o'clock
Yeah.
in the afternoon.
Okay, I so move.
Second.
All in favor of the motion, say aye.
Aye.
So
Thank you, Commissioners.
next step, we've got approval of the SBEC cumulative budget report as of June 9th, 25.
If y'all want to approve it now or save it to the July meeting, you can.
Let's save it.
We're on track. We're doing fine.
I move we save it.
Table it to next meeting. Okay.
Well, because it would be wrong without Commissioner Clemmer.
That's what I was actually.
All right, all in favor of tabling, say aye.
Aye.
All right, director's comments.
Discussed with you the resolution and the plan for the 16th and the 30th, and I'm saving room there in August to resolve any of our other hearing cases. We're working diligently to get these things wrapped up. We're moving into training production stuff, and I appreciate all of y'all's efforts and guidance on this. And we look forward to the next cycle of training and going from there.
I have a commissioner comment. This copy of the rules of procedure for citizens' complaints that we all got from Director Madison today, take those home with you and save them, and then I have to print them again for the next hearings. So you'll have it in front of you, what the appropriate, what everything is as far as what we can do.
So, I apologize. I didn't let you finish.
No, done.
As we're looking at these cases, I recommended decertification earlier. It's not lost on me how severe that is. However, what concerns me about some of these is the fact that we've not received willing compliance in terms of answering questions and being forthcoming. For commissioners, I'm not certain if that's the best way. However, as a result of them having the opportunity to appeal should they disagree and present, in my mind.
If they would cooperate at the beginning, it wouldn't get to this part. So and I think that they will ask for a hearing if they have, a reasonable response. if they call and say, oh, wait, here's my explanation, I'll give you a statement now, it's too late. They have to understand that there are rules to follow. And so then they have to appeal it and come here, and I know it's a drag for everybody. But if we don't do that, then nobody's ever going to cooperate,
Agreed.
I think.
And we try, I mean, I just recognize that unfortunately, these last few counties are some of the counties that we've had some more challenges with. And so there is unfortunately some animosity that, has been attributed to us and staff, and there's no animosity. We're just following what the law and the facts are, and following what the board directs are.
They've had our pictures all over Facebook, okay?
Yeah, and protect their rights and follow the rules and give them the opportunity. And they have the absolute right to either, as I explained, they can accept the offer under protest, or they can reject and ask for a hearing. Hearing is their opportunity to come present all of their evidence to you, and you make the decision based on the evidence presented to you, as we did today.
Thank you. One last request. I know we've asked about training, and should that increase the workload or you need support, my request of you and the team is let us know what you need.
Okay. I actually am working through that, and I believe we're going to, at this next fiscal session, asking for another election coordinator position just to help with the volume of stuff we've got going on.
Thank you.
Any additional commissioners' comments? All right, and with that, we are adjourned. Thank you all.
Thank you.
Thank you.
Sorry this hearing went a lot longer.
Well, it wasn't just the hearing was long. We had,